All rise.
Kosovo Specialist Chambers is now in session.
Be seated. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Salimi, and Jakub Krstić.
Thank you. Welcome back, everybody. Hope you had a restful time over the holiday. I note that the accused are all present in court today. Before we start with today's witness, there are a few preliminary matters. First, the panel will issue its decision on the Veseli, Salimi, and Krasniqi defense request for certification to appeal the panel's decision F02787. On December 16, 2024, the panel issued its decision on the prosecution motion for admission of evidence of witnesses W04826, W04874, and W04875 pursuant to Rules 138, 149, and 154, and related request. The decision was given the filing number F02787 and will be referred to as the impugned decision. On 20 December 2024, the Veseli, Salimi, and Krasniqi defense requested certification to appeal the impugned decision in filing F02812. On 8th of January 2025, the SPO responded in filing F02819. The defense did not reply. The defense submits one issue for certification, namely whether the trial panel erred in its finding that nothing in the specialist chamber's legal framework or in the order on the conduct of the proceedings prohibits preparation sessions with expert witnesses or prevents the calling party from eliciting expert opinion from the expert witnesses on documents not commented in an expert report. The defense argues that the issue presented satisfies the test for certification as one, first, it originates from the impugned decision, is sufficiently specific and identifiable, and does not amount to mere disagreements. Second, it affects the fair and expeditious conduct of the proceedings or the outcome of the trial. And third, its immediate resolution by the Court of Appeals panel may materially advance the proceedings. The defense further submits that the SPO intends to ask the experts to comment on preparatory sessions on fresh additional matters that are not within their original reports. According to the defense, this will result in the creation of an additional witness statement or report in the form of a preparatory note, which is not permitted under Rule 149. The SPO responds that the issue raised by the defense is not specific, discrete, or identifiable. The SPO further argues that the issue would have no impact justifying certification. Accordingly, the SPO submits that the request should be dismissed. The panel recalls and incorporates the applicable law on the legal standard for certification to appeal as set out in its past decisions. The panel notes that in the impugned decision, it found that Rule 149 is lex specialis for the admission of expert reports. The panel also found that, in line with relevant practice and jurisprudence, nothing in the specialist chamber's legal framework or in the order on conduct of proceedings prevents the calling party from eliciting expert opinion from expert witnesses on documents not commented on or in an expert report. The panel further found that, as with other witnesses, the purpose of preparation sessions is primarily to help prepare the witness for testimony and evaluate his or her capacity to provide relevant and credible evidence in respect of facts or circumstances relevant to the case. The panel is of the view that in the issue raised for certification, the defense merely repeats its objections on the scope of witness preparation sessions, as well as the arguments it set out in its response to the SPO's motion, without explaining why the panel was in error in dismissing them. The panel therefore finds that the defense's issue constitutes a mere disagreement with the panel's findings. For these reasons, the panel finds that the defense has failed to establish that the issue constitutes a discrete topic arising from the impugned decision. Accordingly, the remaining requirements of the certification test arising from Article 45, Paragraph 2 and Rule 77, Paragraph 2 need not be addressed. The defense's request for certification to appeal F02812 is therefore rejected. This concludes the oral order. Second, as anticipated on Friday, 10 January 2025 via email, the panel would now like to hear submissions on the Vesely defense motion to exclude evidence from 4500, which is F02822. Do we need to be in private session? Any need to be in private session? All right. Thank you. Does the SBO wish to respond to the motion?
Yes, thank you, Your Honor, and we can stay in open session. Thank you, Your Honor. The defense could and should have raised any objections concerning the relevance of W04500 statement before decision F02816, which found the Rule 144 statement admissible. On the 2nd of January 2025, the Vesely defense indicated that it did not object to the SPO's motion to admit W04500's Rule 154 statement, including the extract now challenged by the Vesely defense. In any event, the challenged evidence should not be excluded from W04500 statement, as it is relevant to the charges in the indictment, forms an inseparable part of W04500's account, and its probative value is not outweighed by its prejudicial effect. While this part of the Rule 154 statement concerns events outside the indictment period, it is relevant to the relationship between identified KLA members, their actions against victims of crimes charged in the indictment, and efforts to intimidate and discredit witnesses. The evidence is therefore relevant to establishing facts and circumstances validly pleaded in the indictment, including by providing context and establishing intent and pattern of conduct. This is consistent with the panel's previous decision, for example, F01700, paragraph 43. The panel has previously held that relevant and probative evidence is admissible and may only be excluded where the defense demonstrates unfairness unconnected to the value of the evidence, such as an inability to challenge it fairly and effectively. And there I'm referring to F01623, paragraph 36. The Vesely defense has not demonstrated any such unfairness. The part of the Vesely motion alleging prejudice focuses on one limited part of the challenged evidence, namely the identification of certain persons as members of SHIC. The defense claims this identification is speculative. However, first, the witness explains his basis of knowledge in relation to the person discussed in the challenged evidence. So his identification of them is not fairly characterized as speculative. And even if it was, the panel has repeatedly held that speculation is not a reason on its own to exclude Rule 154 evidence. Rather, such issues can adequately be addressed by the defense in cross-examination. And there I refer, for example, to F02489 and F02571. At the end of the trial, the panel, as with all evidence, will assign appropriate weight to the evidence at issue in light of the entire trial record. There is accordingly no prejudice and no reason to exclude the evidence. It should be admitted once the Rule 154 requirements are met with the witness. Thank you.
Does the Vasily defense wish to reply?
Your Honor,
Oh,
I
I'm
believe the
sorry.
witness counsel may wish to be heard first.
Go ahead.
Thank you, Your Honor. We support the SPO's position, and we would like to add another element to the argument from the perspective of Victims' Counsel, who represents the interests of this individual. And I would like to go to private session. If we could.
Into private session, please.
Your Honors, we are now in public session.
You may proceed, counsel.
Thank you, Your Honour. Firstly, in relation to the SPO's submission, that this argument should have been raised in the defence's reply to the 154 application. While that, of course, is correct, failure to raise the matter at that stage of proceedings, of course, does not have the effect of rendering otherwise inadmissible evidence relevant. Admissibility of evidence is always a live issue in the case and can always be determined at any stage. In our submission, this evidence is inadmissible, and inadmissibility arguments can be dealt with at any stage. Secondly, in terms of the argument that this is an inseparable part of this witness's account, Your Honour, in our submission, the position is simply the opposite of that. This witness gives two clearly distinct accounts in his SPO interview. One account of an incident that occurred during the conflict, and a second, markedly distinct account of an incident that happened after the conflict. It is the incident that happened after the conflict that we seek to admit, and is therefore clearly distinguishable and easily separable from the 154 statement. And the 154 statement, which deals with the issues upon which the SPO seek to rely, is understandable in isolation. Your Honour will have our written submissions, which deal with the legal test in relation to evidence that falls outside the temporal confines of the indictment. The starting position, as per the law, it's outlined in our application at paragraph 12, is that the default position is evidence outside of the temporal confines of the indictment is inadmissible, unless and until the prosecution can show the test for admissibility is met. So the burden in our submission lies on the prosecution to show how they meet that test for admissibility. And in order to do so, they must strongly and expressly tie that evidence to a matter in issue in this case. And the exact elements of that test are outlined in paragraph 12. The position is that that test simply isn't met. What we have is a vague assertion that there is a link to the indictment by way of relationship. Nothing specific and nothing tangible in terms of what this evidence goes to prove has been outlined. Crucially, in our submission, when the SPO drafted their Rule 95 summary for this witness, it did not mention this incident, so it never sought from the outset to rely upon it. When it drafted its 154 motion, again, silent upon this incident, not seeking to rely upon it. And when the panel ruled as to the relevance of this witness, the panel did not find this incident to be relevant from this witness. So at no stage in the proceedings to date has this evidence ever been deemed to be relevant or sought to be argued to be. There is, of course, identifiable prejudice that would be caused by this, as it would involve protracted satellite litigation into an issue that is of, in our submission, no, at best minimal, probative or evidential value in this case. On that basis, the panel must look at, as we have set out, the probative value and the relevance of this material, which we say is non-existent. Finally, dealing with the question of whether or not the allegations made are speculative. Of course, speculative evidence in and of itself is not a basis to exclude evidence. But when one takes and when one is making this assessment in these circumstances with this burden, when you only have a very speculative allegation being made in those prejudicial circumstances, the fact that the allegation is speculative is of more importance. And my learned friend is incorrect when he says that this is not a speculative application. The core of the issue in terms of speculation is whether or not those who, and I'm conscious we're in open session, that those persons who were responsible for this incident belonged to an identified organisation. He provides a basis for the identity of the persons. That is correct, and my learned friend is correct in that assessment. But no basis of knowledge is provided for the assertion that those persons belong to the named organisation. That allegation is what we are concerned with. That allegation is wholly speculative. And then finally, Your Honour, in relation to the point raised by my learned friend for the victims, while it may be the case that a point may come in this trial where were we to reach a point of conviction, an issue such as this and an illustration of harm would become relevant. In my submission, Your Honour, that is the reparations case if this case ever reaches that point. This nature of harm or any allegation of harm does not go to and is not probative of the issues in this case. It's not relevant to the issues. It's relevant to a different matter that criminal trial proceedings may deal with at different stages. And it should not form part of Your Honour's consideration for admissibility of evidence at this stage. And before I take a seat, I've been informed that there is an error in the transcript. Your Honour, line 10, page 8. It should not say we seek not to admit. It should say we seek to admit. It should say we should seek not to admit.
Yeah, thank you.
I'm grateful, if that made sense. Thank you. Unless I can be of further assistance.
Pardon me?
Unless I can be of further assistance.
No.
Thank you.
Thank you. Anybody else wish to comment?
No, thank you. But as a matter of principle, we support the legal submissions made by Ms. Rowan.
And the same for us, Your Honour. Thank you. Yes, same position, Your Honour.
Thank you very much.
If I may, Your Honours.
Yes.
Excuse me, just to remind everyone that we as Victims' Counsel are obliged to submit our statement on harm at the end of the trial, not in the course of the reparations proceedings, but before the trial ends. Thank you.
Thank you for your submissions. Having heard the parties and the participants, the panel will enter an order on the motion before the start of W04500's testimony. We will now start hearing the evidence of prosecution witness W04875. Madam Court Usher, please bring the witness in.
Your Honour, might I ask, while that's being done, we would be greatly assisted if the panel were in a position to give a ruling today, as it will assist our preparations overnight for the witnesses' attendance tomorrow.
I can't promise that today because we're going to be busy all day.
I appreciate it, yes.
Yeah, thank you.
Thanks.
Good morning.
Witness, the court usher will now provide you with a text of the solemn declaration which you are asked to take pursuant to our Rule 149, paragraph 5. So please read it aloud.
Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will perform my expert analysis conscientiously and to the best of my knowledge, and that I will state my findings and opinions accurately and completely.
Thank you very much. You may be seated now.
Thank you.
Witness, today we will start your testimony, which is expected to last approximately 1 day. As you may know, the prosecution will ask you questions first, and then counsel for the victims. And once they are finished, the defense has the right to ask questions of you. And members of the panel might also ask questions of you. The prosecution estimate for your examination is 1 hour. The defense estimates that it will need 4.5 hours for their cross-examination. As regards each estimate, we hope that counsel will be judicious in the use of their time. The panel may allow redirect examination if conditions for it are met. Witness, please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them you don't understand and they will clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. In the event you are asked by the SBO to attest to some corrections made regarding your statements, you are reminded to confirm on the record that the written statement, as corrected by the list of corrections, accurately reflects your declaration. Please also speak into the microphone and wait 5 seconds before answering a question, and then speak at a slow pace for the interpreters to catch up. During the next days, while you are giving evidence in this court, you are not allowed to discuss with any person the content of your testimony outside the courtroom. If any person asks you questions outside the court about your testimony, please let us know. Please stop talking if I ask you to do so, and also stop talking if you see me raise my hand. These indications mean that I need to give you an instruction. If you feel the need to take a break, please make an indication and an accommodation will be made. Just so you know, at approximately 10 o'clock, we will break for about 10 minutes, and then we will continue on until 11, at which time there's a half-hour break, and then continuing on after that until 1 o'clock, and then we will have a lunch break, and then continue from 2:30 to 4, if necessary. So do you have any questions about any of that?
I do not.
Thank you. We begin now with the questions of the prosecution first. Please give them their attention. They're seated to your left. Go ahead, Mr. Potch.
Thank you, Your Honor, and good morning, witness.
Good morning.
We've met before, but I'll introduce myself again. I'm James Potch, a prosecutor with the SPO, And as the judge said, I'll be asking you questions for the next hour or so. Could you please state your name
My name is William Holger Goodwin.
and your date of birth?
It is 21st of May 1969.
I'd like to call up 103392-103400, and this and the remainder of the items I will be calling up today are not for public broadcast, so they should not be broadcast to the public.
Could you repeat the numbers, please?
Certainly, 103392-103400, and this is going to be the expert CV. Witness, do you see a document on the screen in front of you?
I do.
And is this your CV?
It is, yes.
Are its contents accurate to the best of your knowledge?
The contents are essentially correct. There are some minor changes as the CV was submitted 2 or 3 years ago, but essentially the key details are the same.
Is there anything you'd like to add to it?
I don't think there's anything of significance that I need to add.
Thank you. And, Your Honour, we do seek admission of the CV, given that pursuant to decision F02787, you will only rule on the admission of expert reports once the parties and panel have exhausted all questioning. We can deal with admission of all items tendered to the expert later, which would mean that for now we would just ask for an MFI for this item.
Please give it an MFI, Madam Court Officer.
Thank you, Your Honor. This document will receive MFI number P01950. Classification is confidential. Thank you.
Thank you. Go ahead.
Thank you. We can take this document down, and instead I'd like to call up 103373-103387. And while that's happening, Mr. Witness, this is both for your benefit and for mine. We're an unusual situation in this court. We're both speaking English. So let's both try to pause. So you after I ask my question, and I will try to pause after you provide your response. And that's for interpretation into other languages. And witness, on your screen now, on the left in Albanian and on the right in English, do you see the document?
I do.
And did you prepare this 22nd September 2021 report?
I do. I did.
Now, let's keep the report on our screens in English, please, and take down the Albanian, and instead call up 102472-102482. Now, on the left on your screen, we see a letter of instruction addressed to you and dated 30 July 2021. Is this the letter of instruction on the basis of which you prepared the report on the right side of our screens?
It is, yes.
Do you recall being provided with a number of documents along with this letter of instruction?
I do.
And is it correct that this letter of instruction contained both general questions about DNA and specific questions about a number of the DNA-related documents provided to you?
Yes.
Do you recall reviewing the documents you were asked about in the letter of instruction and making specific reference to such documents in the expert report on our screens?
I do, yes.
And does the expert report on our screens contain your independent opinion concerning the matters addressed therein?
It does, yes.
Do you recall recently being provided with an opportunity to review and provide clarifications or corrections to the expert report on our screens?
I do, yes.
Do you recall that you made a number of clarifications to this report?
I do, yes.
And do you recall that these clarifications and corrections were included in a note which was read back to you?
I do, yes.
And we can take the letter of instruction, so the document on the left, down for now, please. And in the report, which is on the right-hand side of our screen, let's please turn to page 103379 and zoom in on the last paragraph in the main text, please. And I'm going to read from the last paragraph, which you can also follow on your screen. We can see it reads as follows. I have carried out a calculation and estimate the likelihood ratio to be 216,411, that when combined with a prior probability of 1 on 3,000, gives a probability of relatedness as described in the report of 98.63%. I would say that in isolation, this is quite weak evidence for identity. Now, witness, is there anything you would like to correct or clarify in relation to this excerpt?
Based on our discussion and review of it, the term quite weak could be revised to moderate.
And could you explain to the judges in brief why that would be, why you wrote quite weak and now you're saying it could be reviewed to moderate?
It is a subjective judgment. It is based on aligning as best as possible with a likelihood scale that is provided by the European Network of Forensic Science Institutes. And so it is borderline, but it would err towards the moderate rather than the weak.
On the same page, I'm going to refer you to footnote 7 at the bottom of the page. And the penultimate sentence of this footnote reads as follows. No correction was made for population substructure. Witness, is there anything you would like to correct or clarify in relation to this particular excerpt?
When making these calculations, there are a number of assumptions that are included in the calculation. And when carrying out this work, I have done as close as I could to what I believe that the initial calculations carried out by ICMP would have been. I don't know exactly how they did it, but I believe they would not have used population substructure at the time. I'm sure we will discuss through the day whether this is appropriate or not, but in the calculations presented, population substructure has not been used.
And what impact, if any, would including the calculation of population substructure generally have on the results?
The inclusion of population substructure would reduce the likelihood ratio and therefore also the probability of identity.
And would that reduction to the ratio and probability generally be a dramatic or a significant reduction as such, or one that is not significant or dramatic, let's say?
That would depend partially on which pieces of DNA are shared. The impact will be higher on pieces of DNA that are rare within the population and less so on pieces of DNA which are common within the population. As a general rule, as a general guidelines, the population substructure would reduce the 216,000 by an order of 10 to 20. So in this case, the inclusion of a population substructure would reduce this particular value to around 15,000, which is clearly much lower.
And in your experience, is correction for population substructure generally included in identification reports?
Generally speaking, when carrying out identification reports, the inclusion of substructure is not, I would say, not consistently applied. It would depend very much on the laboratory undertaking the work and the circumstances of that work.
And in the same report, let's please turn to page 103384. And there we'll zoom in on the last subheader and paragraph, please. Now here we see what we call an ERN, so the code that we use for a document, which is described as the DNA report for the person whose name appears on your screen. We're in open session, we won't mention names. There's also no need to do so for present purposes. And then your report reads as follows. The DNA profile is encrypted, which limits the potential for full review. However, based on the family members that are available and the matching of encrypted loci, the reported likelihood ratio and probability of identity appear reasonable. And my question is whether there's anything you'd like to correct or clarify in relation to this excerpt.
Without further information, there's nothing that I would like to change about that statement.
And do you recall when we met last week, you mentioned a paper based on simulations reflecting the typical likelihoods of different pedigrees?
I do, yes.
And based on the information in that paper, on those simulations, does that inform your assertion in relation to the family members that are available and the matching of encrypted loci at all?
It does.
In what way?
By carrying out simulations, we can estimate the typical range of likelihoods we would expect to see from different family pedigrees or family trees. So whilst it's not you can't map it over exactly, it gives an indication of the sort of range of likelihoods we would expect from different tests.
And please correct me if I'm wrong, which I may well be. Would that mean that, for example, if the persons tested are, for example, the spouse, son, and daughter of the deceased, there is a certain range or likelihood that you would expect to see? Is that what? Is that correct?
That is correct. We would expect to see different ranges of likelihood with different relatives tested.
We can take this report down from our screens, and instead, I'd like to please call up 111160-111162, and we'll look at the first page, please. Thank you, and now let's turn to the last page, please. Witness, you see that this is a different report to the one we've been addressing thus far. Did you prepare this 6th March 2023 report?
I did, yes.
And did you prepare this report following receipt of a letter of instruction from the SPO?
I did, yes.
Let's please take down the Albanian version, keep the English version on the screen, and also call up 111165-111169. And we see that this, on the left side of your screen, is a letter of instruction addressed to you, dated 15th of February 2023. Is this the letter of instruction on the basis of which you prepared the report on the right-hand side of our screen?
It is, yes.
And do you recall being provided with a number of documents along with this letter of instruction?
I do, yes.
And is it correct that this letter of instruction contains specific questions about one particular DNA-related document, an updated report?
Yes, that's correct.
And do you recall reviewing that updated report that was provided to you and making specific reference to it in this expert report?
I do, yes.
Does the expert report now on our screens contain your independent opinion concerning the matters addressed therein?
It does, yes.
And do you recall recently being provided with an opportunity to review this report and provide clarifications or corrections to it, and noting that you had none to provide?
I do, yes.
Subject to the corrections we discussed in relation to the first report, is the information that you provided in both your expert reports accurate and truthful to the best of your knowledge and belief?
It is, yes.
Subject to the corrections we discussed for the first report, do both your expert reports accurately reflect what you would say if you were examined about the items addressed therein?
They do, yes.
And, Your Honour, we seek admission of the 2 letters of instruction and the 2 expert reports. Since the panel will only rule on admission later, for now we ask for an MFI for each of them. So that's 4 documents in total.
I need an MFI for 103373 to 103387, which is the first report, September of 2021.
Yes, Your Honor, that report will receive exhibit number, MFI number P01951.
And then as to the letter of instruction on that report, which is 102472 to 102482, MFI.
That will be MFI number P01952. Classification is confidential for both.
And then 11160 to 111162.
It will be assigned MFI number P01953. Thank you.
And then 111165 to 111169.
The document will be assigned exhibit MFI number P01954.
Thank you.
Thank you.
Go ahead, Mr. Potts.
Thank you. At this stage, the SPO also tenders the source material related to these 2 expert reports into evidence. The relevant ERNs of the source material are set out in Annex 1 of the witness preparation note, which is 124392-124406. Again, we understand that a ruling on this material will be issued following the completion of the expert's testimony, and also given the volume of the source material, perhaps there's no need to assign MFIs at this stage. We can deal with them at the end of questioning.
That's satisfactory unless someone has an objection. No objection is heard. Go ahead.
Thank you. We can take the 2 documents on our screens down, please. And instead, I would like to call up U015-4164-U015-4164-RED. And side by side with this document, I'd like to call up the first expert report, which now has MFI P01951 And there, I'd like to turn to page 103378, please. Now, witness, so on the left is your first expert report, and if you look at the top of that page, there is a reference number, U0154164, and just to orientate you, that is the document which now appears on the right-hand side of your screen. I'd like to scroll down a little bit on the same page of your report, in fact, to the last two paragraphs. And I'm now going to read this, which you say in your report, concerning the document still on the right-hand side of your screen. You say as follows. However, some elements of the report are unusual. The profiles of the victims and family members are encrypted, so we can't see which loci have been tested, nor the identity of the alleles. As such, it is not possible to recheck the analysis. When making the calculation of likelihood ratio, a reference database would have been used to estimate the significance of sharing alleles. This information is not included in the report, so I cannot comment on its appropriateness. Witness, am I correct in understanding that the information in this item means you're not able to check the ICMP's calculations?
That is correct.
And to your knowledge, what could be the reason or reasons for the encryption of the profiles that you mention in this excerpt?
I believe it would be for data protection, that these profiles could not be used for any other reason other than this particular identification.
And despite this issue that we just talked about, based on your expertise, do you have any concern as to the accuracy of the report that is on the right-hand side of our screen?
In terms of the analysis, or the result, it would be in line with the sort of likelihood expected from this type of family grouping.
Thank you. We can take the document on the left, on the right down. So we'll keep the report there, the expert report there. And let's call up side by side SPOE 0072678-0072750 RED. And here we're going to go to the page ending 72691.
Just to confirm with the council, it's RED because there is another RED. Yeah?
Yes, correct.
Okay.
Just RED, not RED2. And the page is 72691. And in the expert report on the left side of the screen, which is still the same one, P01951, let's first please turn to page 103881. And if we could zoom in on the bottom part of the page, yes. So again, witness, just to orientate you, on the left side of your screen is your expert report, and in bold towards the end of the document, you can see our reference number, SPOE 000072678, and that is the document which shows up on the right-hand side of your screen. I'm now going to ask to turn to the next page of the expert report, where you continue to discuss this document, and you say, and this is the second question and answer on the screen, they read as follows. Does the information contained in this report support the conclusion reached therein? The data is largely encrypted, so it is not possible to fully assess the conclusions. Assuming then the same alleles are encrypted with the same code, the conclusion of relatedness is consistent with the data. Witness, could you explain what you mean by assuming then the same alleles are encrypted with the same code, the conclusion of relatedness is consistent with the data?
Yes, it's the same number is used for the same allele. So if we have a particular allele, the same number is used for that throughout the encryption.
Okay, let's go through the document a little more closely for now. So at the top, and here I'm referring to the DNA report, so on the right-hand side of your screen. And if we can perhaps zoom in the left-hand side portion of that for now. Yes, that's sufficient, thank you. So at the top left of this document, in the first, let's say, box, can we see a reference to D3S1358? Is that right, witness?
Yes.
And then below that, we see allele 1, allele 2, and then 07.4 and 08.9, right?
Correct.
Now, let's start here. Can you explain what this information that I just referred to means or what it refers to?
Okay. Well, first of all, the name D3S1358 is the name of the region of DNA that is being tested. So it's a particular region of the genome, a short tandem repeat that is being tested. We would expect any individual tested to have 2 alleles. An allele is a version of DNA at a particular location. And so where we have different, in this case, for the sample 8105426, we have allele coded 07.4 and 08.9. These are not normal names used for alleles, hence this is why we know it is encrypted. But we expect, in this case, we have a series of relatives below it, where we have a son, 2 daughters. The son and the 2 daughters are the easiest to look at. We would expect that the sons and the daughters inherit at least one of the alleles from the sample, if this sample belongs to the father of those 3 daughters and a son. So allele 1, 07.4, we see that is present in the son, which is the second one down, in the daughter, which is the third one down. And then if we look at the allele 08.9, that is present in the second daughter. The brother also shares the 08.9. This is not so, when we're dealing with siblings, it's not always so clear because we may just by chance inherit different DNA from our parents. So the easiest ones to look at are the direct relations, either parents and children, where we expect to see one of the alleles of the parent in the child's profile.
And in fact, thus far, we've addressed the alleles of the sample 8105426. We also have, correct me if I'm wrong, the code, let's say, for the alleles of the spouse,
Yep.
or the person as the spouse of the victim. And there we have 09.5 and 09.5 as the first entries. And
Correct.
You mentioned in your response that we would expect, and again, correct me if I'm wrong, to see an allele from one parent and an allele from the other in the children. And is that, in fact, what we do see for the son and the 2 daughters?
That is correct. So where we have if you look at the son, we have the 07.4 could have come from the father. The 09.5 could have come from the spouse who has 2 copies of that 09.5. The same applies to the first daughter and to the second daughter. Because the spouse has 2 alleles which are the same, all the children will have that same allele.
Thank you. Let's keep the report on the left-hand side there and take down the report on the right-hand side, so the DNA report. And instead, let's please call up 073-685-073-786 RED, and I'm referring specifically only to RED for now. And in this document, let's turn to page 073-700. Thank you. And in the experts report on the left of our screens, which remains P01951, let's please turn to page 103384. And if we can go scroll down a little bit in the report, thank you. And again, witness here, if you look at Roman numeral 1 towards the penultimate question in the page, you see a reference in bold to a document 073685, and that is the document which appears on the right-hand side of our screens. And in relation to this item, at this page of your report, you state as follows. As most of the information is redacted or encrypted, it is difficult to say whether the conclusions are supported by the information. It is notable that this profile presented in the report, in brackets, page 0173700, PDF page 16, shows data for only 7 of the SCR loci and is an example of a partial profile, in brackets, which is not uncommon when analyzing bone samples. However, the likelihood ratio and probability of relatedness are extremely high, especially as they are based on only 7 loci. I would recommend re-evaluation if the non-encrypted profiles become available. Now, witness, on the document on the right-hand side of our screens, we can see what we refer to in this court as redaction, so the black boxes, and if we can zoom a little bit more closely on those on the left-hand side of the page, we can see that they have an E code. That's just so that you can follow. Now, instead of this version on the right-hand side of our screen, I'd like to call up 073685-073786 RED2 and turn to the same page, which is 073700. And if we can again, yes, thank you, witness. What you have on the right-hand side of your screen is the same document we looked at earlier, so the same document that you talk about in your report, but this is what we refer to as a lesser redacted version. And in fact, here we're able to see more information. Can you tell the difference between the version on your screen now and that before?
I can, yes.
And in particular, on the version on your screen now, we're able to see the types of family relationships of the persons tested. So now we see in the table on the bottom or the middle part of the screen, mother, father, spouse, daughter, son. Could you tell the judges whether this additional information, i.e., or that is the type of relationship, as I said, mother, father, spouse, daughter, son, has any impact on your assessment? Which assessment stems from your report, the excerpt that I just read out?
It does, yes. In this particular case, we have a very complete pedigree. We have the mother and the father, which alone with a missing person can give a very high likelihood. And then in addition, we have the son and the daughter along with the spouse. So collectively, we'd expect each of those loci to return a high likelihood. And so the figure becomes plausible.
Thank you, witness. And Your Honor, we have no further questions for this witness.
Before you begin, we'll take a 10-minute break, as I stated earlier. Please escort the witness out. We'll take 10 minutes now, and then we'll start back with questions from the defense.
Your Honour, if I might just check before we break to assist me in asking questions, I'll go first for the defence teams. The position with confidentiality. All of those persons that are concerned with these DNA samples are all public in the indictment, bar two. In those circumstances, we had been proceeding on the assumption, therefore, that these DNA reports could be named, the reference samples referred to, as these are public victims in this case. So it's not clear to us why any of the reports that concern public victims in those circumstances would be confidential. And secondly, the experts' reports, letters of instruction and CV, while of course they contain personal information like his mobile number, which of course should be redacted, again, we don't see any reason why they should also be confidential. It may be simply that redacted versions need to be provided. But we would ask the panel to consider that matter because, of course, the default position should be public.
Wish to be heard.
Yes, thank you, Your Honour. In terms of the mentioning of victims, I would need to double check. I believe that the victims listed in Schedule B to the public version of the amended indictment are mainly redacted. Even if the victims' names are available to the public, we're dealing with very sensitive issues here, which is the identification of specific victims, family relations, and as I think I established by the way I proceeded, there is actually no need to name names while we're doing these things that could cause undue harm or stress or be or psychological, have an adverse psychological impact on the victims and families of the victims. In terms of the classification of the documents, this is how we always proceed. A document is either public or confidential. If it comes to later on and there is an order to prepare a public redacted version, we can certainly do so.
Thank you. Consider that an answer before you begin. Take the 10-minute break now.
All rise.
We're adjourned.
All rise.
Be seated. Please bring the witness in.
Your Honour, my apologies. Before we do that, could we please have clarity in relation to
Hold on just a second.
the confidentiality?
I can't hear you. Okay, go ahead.
Your Honour, pardon me. It was simply to ask for clarity in relation to the mentioning of names and confidentiality of documents
Yes,
before I proceed.
I believe we should leave it the way it is now. We will not be mentioning the names. We believe that the report should be redacted and made public, and that the instructional letter should be redacted and made public. But there are still some names that cannot be repeated. Relatives who gave a sample, for example. So we would rather leave that out for now.
Your Honour, then on that basis, 2 of, I believe, 26 potential identified victims, only 2 are redacted. So of course I won't refer to those. But in those circumstances, in circumstances where family members are identifiable, those documents cannot be public, but it is possible to mention the name of the possible ID as in line with Rule 120. The reason to keep that confidential would be to protect identity of victims. But of course, these victims are in fact identified, so should be able to be named.
Wish to be heard on that?
Yes, Your Honour. As I mentioned before the break, we would object to that. The reasons why we don't make certain documents or information public isn't merely that a particular victim or witness has incorporative measures. There is also the psychological well-being of the victims and the witnesses, the relatives in particular in this case, to be protected. And so we haven't heard anything as to why we can't proceed as we have thus far.
Yeah, I don't understand the importance of going into the names, since the information is evident to us and that's all that's necessary.
Your Honour, in any trial, the court in our submission should seek to endeavour to ensure that all information is public.
Understand that, and we do
Yes.
understand that, and we do try to seek it, but it is, in this case, we are not convinced that it should be made public.
Yes, but my
So
Lord-
that's the ruling on all the names.
Very well.
Be seated. Witness, we continue now. The Vasily defense, seated to your immediate right, will first be asking questions. Ms. Rowan, go ahead.
Good morning, Mr. Goodwin. My name is Kerry Rowan, and I ask questions on behalf of the second defendant in this case.
Good morning.
I'll try and remind both of us, but primarily myself, to watch speed, because we're both going to be speaking in English for the rest of this morning. What I'd like to just do at the outset, because I'm sure you're anxious to know where we might be going for the next couple of hours, is just to outline the broad topics that I would wish to address with you in your evidence. I'd like to look at the limited nature of the instructions that you received from the prosecution, what you were and what you were not asked to do. I'd then like to look at DNA profiling of skeletal remains a little bit more broadly. Thirdly, I'd like to explore, with your assistance, the limits of some of the data that you were provided with in this case, and the impact of that limited data set. And then finally, I'd like to look at just some potential issues that arise from that underlying data. So that's where we're going.
Okay, thank you.
All right, so Mr. Goodwin, it's right that you were instructed initially by the SPO in this case in July 2021, is that right?
That is correct.
And prior to July 2021, you did not have any involvement with any of the cases that these reports are concerned with, is that right?
That is correct.
You weren't involved in any of the initial DNA extraction or sampling processes that were conducted.
That is correct.
You weren't involved in any way in the creation of the reports that you were asked to look at as part of your instruction.
That is correct.
So when we look at the data set that we have and the conclusions in those reports, those are the conclusions of others. They aren't your conclusions.
They are the conclusions of the ICMP who carried out the work.
Yes. Sometimes we can identify who that might be, sometimes we can't.
Right.
Correct. Now, it's right also that you have not had the opportunity to speak to the persons who conducted those reports.
That is correct.
And you were not invited to do so by the prosecution.
I was not invited, nor did I ask.
Yes. And as we dealt with a moment ago, it's right that when we look at the array of reports that we have, a number of those, it's impossible to identify the person who authored the report, but in some cases it is possible. In the minority of cases, we can identify the author of the report.
Based on the information provided, that is correct.
And I hope I have my count right, but in total you were asked to look at, I believe it's 26 reports related to unknown DNA samples. Does that sound about right?
Yeah, you've counted more recently than I have, but I don't object to that number.
I'm sure we'll be corrected by somebody in the room if one of us has gotten it wrong. And it's right that all of those reports that you looked at, with the exception of one, that one being the report that was subject to your additional second report, all the other reports originate from the ICMP.
Yeah, I believe that's correct, yes.
And in each of those reports that you examined, the conclusion, for various reasons, in various reports, those reports cited a possible identity match to persons connected with this case.
Correct.
Could we then just please look at your letter of instruction? I believe this is now MFI 1952, please. And this should not be publicly broadcast in line with the panel's ruling. So this is the letter, Mr. Goodwin, we've looked at a little bit earlier. And so that we're clear, a letter of instruction is a document that is sent by a party in a case to an expert, setting out what that party wants the expert to do.
Correct.
It is a document that instructs you in your capacity as an expert to answer certain questions and conduct certain analyses on behalf of your instructing party.
Correct.
Now, when dealing with this case, this was the original letter of instruction that you received, setting out the instructions by the prosecution.
Yeah, I believe that is correct.
We might as well just clarify at the outset. I will not be asking you any questions in relation to the DNA report that was subject to your second letter of instruction and your second report. So you can take all my questions as confined to this letter of instruction if that assists.
Understood.
So if we just go to the Annex 1, please, which is where the specific questions are contained. It's page 3 of the PDF, please. All right, thank you very much. So if we look here, the first thing that you were asked to do by the prosecution was simply to provide some definitions for scientific terms that could be found in that underlying material. That's right?
Correct.
And you were also asked, we can see, some general questions about how DNA testing can assist in establishing identity of remains in a broad sense.
Correct.
And if we then go down a page, please. The report then came on to ask you some more targeted questions about certain DNA reports that you had been provided with. Is that right?
Correct.
Now, you were provided with material by the prosecution, and we can see, can't we, at the top of this page, some quite long, we call them ERN numbers. Those numbers, for example, ITO 484 bis. That applies to one of the documents that you were provided with by the prosecution. Is that right?
Yes.
So you were given a confined data set by the prosecution from which to work, and we see the record of that data reflected in this annex. Is that correct?
Correct.
Now, would you agree that when we look at the questions that you were asked by the prosecution, you were asked to take quite a targeted approach to your answers? You were asked specific questions about specific documents, and they are set out as we see here.
I would agree that the questions were quite precise.
Yes. There wasn't very many broad or overarching questions contained within this annex, save for how does DNA analysis work in general?
There were not.
Yes. Now, fully in line with the instructions that you were given, you followed those instructions to the letter, and the report that you produced ultimately were answers to those questions and no more, as that is what you were instructed to do. Is that right?
That is correct.
So if we could just step back then and just look at what you were not asked to do by the prosecution, looking at the black letter of this instruction document. So you were not asked to conduct a fresh analysis of any of these conclusions, or of any of these findings, pardon me. You weren't asked to conduct a fresh analysis of your own.
By a fresh analysis, can you define what you mean by a fresh analysis?
Yes, you were not asked to do the work again, analyse these DNA profiles again, and come to your own conclusions as to what the likelihood of a match would be in your opinion. You were not asked to do that work.
As in the practical work?
Yes.
I was not asked to do that.
You weren't asked to do the maths. You weren't asked to do the analysis again. I
think some questions where I did offer a mathematical
Yes.
opinion. I can't specifically remember whether I was asked to do it or not.
You did. You helpfully, for a number of the reports where some of the numeric figures hadn't been translated into percentage probabilities, you
Yeah.
assisted us by converting those.
Okay, yeah.
That is correct. But in terms of being asked to do an analysis, you weren't asked to reanalyze these profiles. Whether or not that's possible or not, we'll come on to.
Just so I'm make sure are you talking about looking at actual DNA profiles?
Yes.
No, I did not see any of the DNA profiles. I only saw the conclusions of the DNA profiles.
Yes. We'll deal with in a moment what may or may not be possible for you to do had you been asked to do it.
Yeah.
Which is limited by your last answer. You were not asked to confirm the accuracy or the veracity of the conclusions in the reports. You weren't, in terms, asked to do that.
No.
You were not asked to confirm whether the methodology, as you could see it, if at all, met with a satisfactory standard in your opinion.
Correct. I was not asked to comment on the methodology.
And you were not asked more broadly to highlight any concerns, deficits, or weaknesses that you were in a position as an expert to identify in this underlying data set.
That is correct.
Now, I believe it's been mentioned already. It's right that you had a what we call a preparatory session with the prosecutor last week.
That is correct.
So you spoke to a number of members of the prosecution team via Zoom about the evidence that you were going to give today.
That is correct.
Now, in that Zoom, one of the things that you raised with the prosecution, quite fairly, was your status as a witness in this case. Do you recall that?
I do, yes.
And you had explained to the prosecution that in the UK, which, am I correct in saying that's the jurisdiction in which you ordinarily work or reside at present?
I am based in the UK.
Yes. Because as you informed the prosecution, in the UK you would be considered as an expert of the court.
Correct.
And you saw clarity on whether or not that was also the position as far as you were concerned today.
That is correct.
Because it's right in the UK, isn't it, when you give an expert's statement, attached to every expert statement you would see in the UK is a lengthy expert's declaration that all experts are required to sign, which gives the court guarantees that all evidence being given is independent, unbiased, putting the court first and neither party.
Correct.
And you were properly assured by the prosecution that that equally applies to your evidence today.
Correct.
And are you aware that you are the only DNA expert that the SPO is calling in this case? Was that made clear to you?
That was my understanding.
Yeah. All right. If we could step back and more broadly just deal with extraction of DNA from skeletal remains.
Yeah.
Thank you. All right, so methodology of extraction for DNA from skeletal remains. Taking the whole data set that we're dealing with, is it right that all of the samples, the initially unknown samples that are dealt with in these reports, all of those derived from samples of bone collected at autopsy from exhumed remains, as far as you understood?
That would be my understanding.
So what we're dealing with for all of these reports is exhumed skeletal remains.
Yes.
Now, sometimes we have, and we've actually seen it already looking at one of the reports. Some of the reports we can see a photograph of the bone sample that was used for extraction purposes. Is that right?
That is correct.
And commonplace, we see that on the bottom left-hand corner of these reports
That is correct.
where available. Now, it's right, because of the paucity of information that we've been provided with, that we don't know the methodology that was deployed in that extraction process for those bones. Is that right?
That is correct.
And because we simply don't have that information available to us, you, in your capacity as an expert, are not in a position to comment on the quality or appropriateness of any methodology that was deployed when seeking to extract DNA profiles from those samples.
That is correct. I do not have knowledge of the specific methods used in the cases that we are looking at.
Interpreter's note, we kindly ask the speakers to pause between question and answer. Thank you very much.
My apologies. It's our first warning, Mr. Goodman, to slow down. I'm sure it's my fault. In the absence of that information, therefore you're simply not in a position, nor could you be, to confirm that the extraction procedures used would meet a standard that you would deem to be satisfactory.
The requirement for an extraction would be that you recover DNA from a single source. And so where we have a profile, we can infer that DNA was recovered.
But we don't have the profiles in this case, do we?
Well, we have either the profiles or a coded version of the profile.
We have a coded version of certain loci within the profile, but we do not have the raw profile. Is that right?
We do not have the raw DNA profile to interpret. That's correct.
Yes. Okay. Now, extracting DNA from exhumed bones, would you agree, is a very sensitive exercise?
It depends on the bone. It depends on the condition that the bone is in when it is recovered. And so it is a extended process compared to most forms of extraction. So, for example, the reference samples that are used, either blood, typically blood, is much easier. But you can usually get a lot of DNA from bone if it is not being subjected to too adverse an environment. But it takes longer.
And of course, you don't know the condition that any of these bone samples arrived in the laboratory in, as we don't have that information.
I do not know that information.
Would you agree that when dealing with bone samples and DNA extractions from bone samples, that in those circumstances that there is a heightened risk of contamination as compared to other work that might be done in extraction?
Again, it depends on the condition of the bone. Many bone samples will have a large amount of DNA, and so in those conditions, contamination is no more likely than with reference samples.
Would you agree with this? The reason that it can often be a sensitive exercise is because often, albeit not exclusively, the amount of DNA that you can extract is limited. Therefore, when you are dealing with small amounts of DNA are at a heightened risk of contamination.
That would be a fair point.
So, where we have a small amount of DNA extracted and that we're working with lab technicians, scientists dealing with that, must take, would you agree, precautions additional to what you might have in relation to other samples to protect against contamination?
I would say precautions should be similar, because you should be careful with all.
Of course.
All samples. There are precautions in reference samples also. So yes, precautions should be taken to minimise the potential for contamination, of course.
As you mentioned, it's of course applicable to all, but it is important to have robust procedures and ideally mitigation measures in place when dealing with samples such as this.
Yes.
Now, when we're talking about contamination, and perhaps just looking at what we mean by contamination at the lab, for example, contamination may be contamination of the sample that you were looking at with a DNA sample that's come through that lab in recent times, or contamination, for example, by a staff member. There are different types or forms of contamination that can happen, and that we need to look to put mitigation measures in place to protect against in a laboratory.
I would agree, and I would say this applies to all samples.
Yes. But it's right that certain labs will have different types of mitigation measures in place or different procedures in place to protect against those risks. Not all labs are uniform in their approach.
There are similarities, but of course each lab has its own distinct procedures.
For example, quite a common mitigation mechanism that you would see in the UK, for example, would be when dealing with a sample such as this. A common mitigation measure would be when the DNA sample is extracted, one would run that extracted sample against the last 6 months of samples that that lab has seen cross its doors to ensure that your new sample hasn't been contaminated by any of those in the last 6 months. It's a common mitigation measure.
Whether 6 months, but yeah, for certainly to compare against a batch of previously extracted samples, yes.
Yes, and sometimes, again, to compare against staff.
It would always be to compare against staff.
For obvious reasons that the lab techs themselves may inadvertently contaminate samples.
Correct.
But it's right that, again, for all of these reports and for all of these samples, we simply don't know what procedures were in place to mitigate against any contamination risks.
No, I cannot speak to that.
And because we can't know what they were, you, of course, cannot comment on whether or not they would be, in your opinion, sufficient.
Correct.
Okay, can we deal, please, Mr. Goodwin, with commingling of bones? Now, by commingling, that can refer, would you agree, to bones that may be found together, moved together, stored together? Or would you have a more precise definition?
No, commingling is the fancy word for mixing of bones from different bodies.
That being the key, it's not the mixing of bones from an individual body, it is the mixing of bones of more than one body.
Of more than one body.
And would you agree that where we have commingling of bones, that there is a risk of contamination amongst those bones?
The potential for contamination exists, but I would say it was very low, given the procedures that all laboratories would undertake in a laboratory once they receive a bone.
Now, just in terms of best practice when dealing with bones, would you agree that best practice when setting out upon looking to extract a DNA profile from a bone, best practice would say that you should send that bone sample to a different laboratory to one that does ordinary day-to-day DNA sampling? That best practice dictates it should go somewhere else to reduce that contamination risk.
I think it should be extracted in a separate area. I don't think it necessarily, I don't think any laboratories would send their samples to a different laboratory necessarily. I'm looking at the UK example for that. The crime scene samples are processed in the same facilities, albeit in a different room to the reference laboratories. So whilst in a perfect world, it might be nice to have a separate facility just to deal with the bones, I wouldn't say it was a requirement.
No, not a requirement. As I stated, best practice, in an ideal world, you would like them to go separately.
In an ideal world, it would be nice,
Yes.
but yeah.
If practical, often not.
Yeah.
And would you also agree that, again, in an ideal world, in a situation where you're dealing with commingling of bones, if it is possible to identify samples as likely originating from separate deceased, by that I mean, for example, we may have 2 leg bones. We may therefore think that likelihood is that they come from 2 different deceased persons. In a best case scenario or in an ideal world, we would also like those 2 bones to go to 2 separate labs to reduce the risk of contamination, if possible.
I think that would be over specification, to be honest. I don't think you would need an awful lot of laboratories in the world to process if you were sending every sample to a different laboratory. I say based on processing of crime scene samples, they're done in the same facilities.
All right. Now, when we talk about contamination, I just want to look at what we actually mean by contamination when we talk about a DNA sample getting contaminated. So what we mean by contamination is that the DNA profile that's extracted may become mixed with another DNA sample, or more than one other DNA sample, mixing is a form of contamination. Would you agree?
Correct.
And when mixing occurs, we can see mixing of a DNA sample with 1, 2, 3, any number of other samples of DNA.
Correct.
And it's not uncommon for laboratories to have to deal with mixed samples on a day-to-day basis. Is that right?
Laboratories that process crime scene work see a lot of mixtures just because the samples they receive are mixed when they receive them.
So perhaps if we look at that crime scene example, and we just take a real-world example just to place us in what we're talking about. If in the UK a crime scene was being processed where there had been a violent incident and there was a cap, a baseball cap left behind in the crime scene, and that cap was sent for analysis for DNA. Something like a cap is something that can be worn by multiple people, and it is possible, for example, that in the brow of that cap, a lab might find a mixed profile of DNA.
Quite probable.
Yeah, so that's an example where we might see it in a crime scene setting.
Yes.
But where we're looking at mixed profiles in this setting, we are talking about after the DNA profile has been extracted from bone, at some point and for some reason along that process, that profile has become contaminated and mixed with another DNA profile.
Another DNA source.
Source.
Yeah.
Thank you. Yes, another DNA source. And it's right that because it's not an uncommon event for labs to deal with, that all labs should have some sort of procedure in place to deal with mixing when it occurs.
Laboratories would be able to identify mixtures because the profile of a mixed sample is different to the profile of a non-mixed sample.
I'm being reminded to slow down, so I'm going to try to do that. But again, the procedures in place for mixing can vary. For example, in the UK criminal context, which we've mentioned before, in the UK, when providing results, mixed profiles are never omitted. They're almost always included in a criminal setting within the results.
Yeah, if you'd obtained a mixed profile, you would report on a mixed profile.
Exactly, whereas there are cases on certain labs where mixed profiles are identified, if indications of that mixture do not meet certain thresholds, the lab disregards what may be evidence or considered to be evidence by others of mixing.
Okay.
Would you agree that that can happen?
I think it's very context specific.
Yes.
I wouldn't like to make general comment on it.
It is possible, would you agree, therefore, that it's possible when looking at profiles without having access to the EPG, come on to deal with EPGs in a moment, but it's the DNA profile.
Yeah.
Without access to the DNA profile,
Yeah.
you cannot tell, or an expert cannot tell, how mixing has been dealt with.
Correct.
And because in this case we don't know how mixing has been dealt with, because we don't have the DNA profiles, we don't know if any of the profiles that we're dealing with are or could be mixed. We can't exclude that.
We have there's no evidence in the profiles that we've been given that there's been any mixture. But we cannot, whether samples were excluded because there was mixture is a possibility.
Yes. So without you having the opportunity to examine those raw DNA profiles, you cannot definitively exclude the possibility that we're dealing with mixture, i.e. contamination.
Okay, I'm taking it on trust from the reports when I'm commenting on them that was a single source profile. And I have no way of, as you said, we've not looked at the DNA profile, so that is taken on trust.
So would it be fair to say that you giving your fellow scientists due deference may assume that that is the case, but you cannot confirm it to be correct or confirm it to be true?
Correct. I have not seen the DNA profile, so I cannot comment on it.
So let's deal with DNA profiles, which might be the elephant in the room that we keep referring back to. And And I'd just like to do that in a little bit of detail before we start to come on to deal with these reports.
Sure.
What does EPG stand for?
Electropherogram.
Now, an electropherogram is the DNA profile, that raw DNA profile, is that right?
That is, it is the output that we see as a scientist of the DNA profile, yes.
The full DNA profile.
Yes.
Now, EPG, in terms of what it is or what it looks like, in terms of the format that it appears in, it appears ordinarily in a graph form with peaks and lows.
That's correct.
And those peaks and lows on that graph is what results from the sequencing done after looking at the DNA, is that right?
Results from the amplification of the DNA and the different amplified pieces within the DNA show us peaks, as you say, on the electropherogram.
And that's after using PCRs as part of the multi-mixes, which we'll come on to deal with in a moment.
Exactly. The PCR amplification allows us to detect the DNA.
Yes. And it's right that what it also does is it illustrates individual areas of DNA in different colors, so you can differentiate the different areas of DNA.
The different pieces of DNA, we refer to them as by the loci before, are either differentiated by size or by color, or combination of size and color.
So when you are in possession of that EPG or that DNA profile, you as a scientist are in a position to examine the whole DNA profile, ideally, all the different loci, as distinct from each other.
Correct.
Now, perhaps for the next questions, again, I'm going to ask you for your help just on some definitional points again before we get into specifics. But it might just help us, I think, to have a copy of one of these reports with us so that we have a reference point. Madam Court Officer, could I please have P854, page 197, not for public broadcast, please. Apologies, Mr. Goodman, we're going to be moving through one or two documents, and we do everything digitally. It would be easier with a hard copy bundle, but we'll have just a few delays getting stuff up on screen.
No problem at all.
So you know what's coming up.
Excuse me, you're still talking over each other. Please pause briefly before answering a question.
It's page 197 of this, please. And Mr. Goodman, for your reference, what we're going to be looking at is one of the underlying summary reports that you have examined in the course of your report. And also just for your reference, this is also one of the reports that was in the body of the additional expert report that you received.
Okay.
Okay. So it's one of those. And we can see, for our reference, the possible identity recorded on that. And we can see in the top left that this derives from the ICMP. Now, Mr. Goodwin, is it right, just to orientate ourselves with this, that this is, we've seen one of them already, the standard format of the reports that you've been looking at as part of your analysis in this case?
Correct.
And most of this page, or most of these pages when we see them, comprise of this chart form in the middle.
Correct.
And they are the purported DNA results from the amplification testing.
Correct.
All right. Now, would you agree that we can tell, looking at it, or you can tell, looking at this report, because of how it's set out and the information contained within it, that we're dealing with an STR or DNA profiling technique?
Yes, a typical SDR profiling report.
Now, could I ask, please, Madam Court Officer, can we just zoom in on maybe the top left-hand corner, please? Just stepping back from the report a moment ago, you had dealt with this in examination in chief, but perhaps if we could just run over it very briefly. The loci or the locus of a DNA, on DNA, that refers, would you agree, to the specific location of a genome within the DNA. Is that right?
It refers to a specific location within the genome, yes.
Its location. So when we think locus, we think location.
Yes.
Genes have many different loci. When we're looking at individual one, we're looking at individual location on the DNA.
Correct.
All right. Now, if we look at this report, we find the loci. Now, because the difficulty with these reports is they're not labeled. So if we look at that top row, and where it says D3S1358, that top row of a variety of numbers, they're the loci that are being tested. Is that right?
Yes, they are the different loci, yeah.
Could I ask you, there should be a pen on the right-hand side.
Oh, yeah.
Yeah, like a digital pen. Could I ask you, please, with the assistance of Madam Clerk, could you just circle that first box at the top and put an L beside it so we know that they're the loci when
This
we're
one
dealing
here.
with these? Yes,
Yeah.
please. And maybe just put an L. Thank you. So in any of these that we're looking at, that top line is the loci. Now, when doing relationship testing, scientists only look at a specific collection of loci, is that right?
Yes.
And there's a reason behind that, because humans actually share quite a large amount of identical DNA. So when we're looking at relationship testing, what scientists are actually looking to explore is the DNA that changes the most.
That is correct.
So we see in this, we don't have the full screen up, but there's 16 loci looked at this.
Yeah.
And we always look at one to tell us the sex.
Yeah.
All right. And we can see that one here, AMGXY. That will be the sex loci looked at.
Exactly. That's the amelogenin locus.
Could you circle that for us maybe while we're here, please, the AMGXY? This is what we look at when we're looking at sex. Thank you. And maybe if we put an S beside that. I'm conscious we'll have to come back at some point to understand these markings, so if we just mark them accordingly, please. Thank you. Now, Mr. Goodwin, alleles. Alleles are the loci that are analysed as part of this relationship testing, because the alleles are what come in the different forms that we spoke about. They're different versions of the loci that we can see in different people. Is that a correct description?
Yes, the allele will be different variants of the particular piece of DNA that we are looking at.
Right. So we're looking at a piece of DNA, we're looking at a loci, and we're trying to see what version of that loci this sample has.
Yes.
And there we look at the alleles.
Yes.
And we see then in the second row here, we have allele 1 and allele 2.
Yes.
So that's what's being looked at here, is what type of allele for that loci does this person have?
Correct.
Could you circle maybe underneath THO1, allele 1 and allele 2, just so we see where they appear? Thank you. And maybe if we just put an A beside those. Thank you very much. Now, alleles are capable of being measured, is that right?
Correct.
And as we referred to earlier, the ordinary way of measuring alleles is looking at their height within the DNA profile or the EPG.
We characterize them based on their length, which is determined by looking at the EPG.
Yes.
Well, or the software underlying the analysis of the EPG.
The software that runs the EPG.
Yeah.
Yes. So, STRs. That's also a term that's been referenced already. as
STR,
well.
yes.
Apologies, the Irish accent catches.
That's quite
the
okay.
STRs are short pieces of DNA which essentially repeat themselves. Is that right? Short tandem repeats, the pieces of DNA that repeat.
That is correct. They are short tandem repeats.
And when you look at the DNA, when we're looking at DNA in this setting, we're looking at STRs that appear in base multiples of 4. Is that right?
With the exception of penta D and penta E, which occur in base multiples of 5.
And we can see penta E as the 5th one in, and penta D just beside the AMG toward the right-hand side. Is that right?
Correct.
So with the exception of those, we are looking at STRs that repeated base multiples of 4.
Correct.
These two, base multiples of 5.
Yes.
Okay. Now, in terms of what you would refer to as allelic designations, so when you're looking at alleles, alleles in DNA testing are traditionally reflected in numeric form.
That is correct.
And what one would ordinarily expect to see when looking at the results for allelic designations that derive from the PCR testing would be whole numbers or whole numbers with a 0.2. That's what we would ordinarily expect to see.
We ordinarily expect to see whole numbers or with a point, and the point can range from 1 up to 1 short of the full repeat. So they can be 0.1, 0.2, 0.3.
Well, Mr. Woodham, would you accept from me that ordinarily you would not expect, well, ordinarily what you would expect to see is whole numbers or a whole number 0.2. That's what ordinarily you would expect to see.
I would disagree. It depends on the locus. If we look at locus Tho1, we see a 9.3. That particular allele is very common, so we were certainly not surprised to see Tho 9.3.
You picked out the exact example we were going to come to in a moment. Other than the situation being that normally you would expect whole numbers and 0.2s, you can and do see on occasion 0.1s and 0.3s. And the example that we have here is we have a 0.3. And while not common, does occur.
Correct.
All right. So can we just clarify that? Because I appreciate we've been back and forth a little bit. Would you agree that ordinarily, when you are looking at allelic designations, what you expect to see in the results are whole numbers or whole numbers with a 0.2, but it also can occur that those allelic designations appear with a 0.1 or a 0.3, albeit not very commonly.
That is correct.
But you do not expect ordinarily to find any decimal points beyond 0.3.
In the pentarepeat, you could potentially have a 0.4, although I think that would be very rare.
Very rare. And certainly nothing beyond that.
No, because then it would be another full repeat.
And because STRs repeat in bases of 4, that doesn't happen.
Well, if we had, when we get to 0.4, we have a full repeat, and so we would have a whole number.
Exactly. So you would not expect to see, for any allelic designations, anything beyond a 0.4, and even the 0.4 being very rare.
Yes.
Thank you. Now, a person will typically have, or should have, 2 alleles for every STR, one from each parent. And that's why we see allele 1, allele 2. Everyone should have 2 alleles for each STR.
That is correct.
All right. And that is why we use this analysis when looking at relationship testing. It's because you get one of each of these alleles from a parent. So this is how we use these results to try and determine whether or not persons are related.
Correct.
I'm just conscious of the time. I'll do one more topic with you, or
Sure.
one more aspect with you before we break for the half an hour. Multi-mix testing. When looking to use DNA to confirm existence or not of relationships, you mentioned a moment ago what labs use is something called multi-mix testing. Is that right?
I call that multiplex.
Multiplex.
Yeah.
Multiplex testing. And what they are tests that are a manufactured set of DNA probes. Is that right?
They are a set of manufactured PCR primers which will target the particular loci, for example, the ones listed here.
And the PCR amplifies the DNA to enable us to see the full profile.
The PCR take a very small amount of starting DNA and we amplify the bits that we are interested in, and only the bits we are interested in, and that allows us to analyze them.
And you say the bits that you're interested in. So ordinarily, when looking at relationship testing, you don't look at the whole profile when doing the analysis of whether or not a match exists. These tests focus upon, ordinarily, 16 loci. Is that right?
Okay, just for precision, say we do look at the whole profile.
Yes.
We don't look at the whole genome.
My fault, pardon me.
No, I just wanted to be
Yes.
precise.
No, it's very important that you are. Ordinarily, and as we can see here, we have 16 loci.
Yep.
So when we're doing relationship testing, ordinarily a science will look at, and these tests look at, 16 loci specifically.
In this case, yes. I mean, we can have different multiplexes,
Yes.
which will look at fewer or more.
But Powerplex 16 is the standard.
It was the standard
Yes.
at this time.
Yes.
It has been superseded now, but certainly for 15 years, starting from around the 2000s, it was one of the two standard kits in use around the world.
So the first half of the noughties that we're dealing with in these reports, standard test.
Yes.
All right. Your Honour, is that a convenient time?
Witness will take the half-hour break now. Please leave the courtroom with the usher. Please do not speak with anyone.
All rise. All rise.
Be seated. As to the objection by the Vasily defense to disallow certain testimony of witness 4500, first, as a procedural matter, the defense should have raised this objection at the time of the 154 response. It failed to do so and failed to show good cause as to why the extension of time would be warranted. We reiterate that in principle, parties are expected to respond in a timely manner, and this was not done here. The application is, in effect, an application for reconsideration of our decision F02816, the test and standard of which was not applied nor met by the defense. However, in its discretion, the panel can, on an exceptional basis, agree to consider the new belated arguments put before it by the Vasily defense. The part of the evidence which the Vasily defense now challenges is relevant and meets all other requirements for admission under Rules 154 and 138. On relevance, the impugned evidence goes to show what could amount to an attempt to interfere with the account of a witness
Welcome back, Mr. Goodwin. Picking up where we left off, I hope you should still have on your screen the document that you were marking before the break.
I do, yes.
Excellent. If we could just look at that before we move on in a little bit more detail. You'll recall that before the break, you were explaining to us the type of allelic designations that you might expect to find in such a report. Those allelic designations you would expect to find being whole numbers. If we just look just across this row, we see, bar one exception, whole numbers. Is that right?
Correct.
And that is what you might anticipate seeing in a report such as this.
Yes.
And you've pointed out to us already the one exception to that, in a spot exactly where you might expect to see it, which is TH01, and we have a 9.3.
Correct.
Just in terms of the numbers themselves, in addition to anticipating in results such as this whole numbers, it's right that when looking at these loci, you would anticipate figures 10 plus. Would you agree?
Sorry, could you repeat the question?
Sorry, it was a per question. In addition to anticipating whole numbers, the types of numbers you would expect to see, you would expect to see numbers above 10, not below 10. Would you agree with that? Ordinarily.
That depends on the locus.
For these locus that we're looking at now,
Yeah, if we look at D7, which is around halfway along, you'll see there's an 8 and a 9, which are not unusual. I can mark them if you like.
please do.
So we've got 8 and 9 there, we've got an 8 here, we've got a 9 here. So it depends very much on the third one as a 9. So the number is just a reflection of the number of repeats
Yes.
in that piece of DNA, and so it depends on the locus as to how many we see.
Another good example, perhaps, would be the third one in. We have D2, 1S, 11. For that loci, you do expect numbers over 20 usually, is that right?
Typically, yes.
Typically. So when looking at results for that particular loci, you would anticipate seeing numbers over 20, and that's exactly what we have there.
Correct.
And obviously we have the exception of D7, which you pointed out.
Mm-hmm.
But would you agree that for the majority of these loci, one would anticipate a figure over 10?
Interpreter's note, we kindly ask the speakers to slow down and make a pause between question and answer. Thank you very much.
Your answer, so it's reflected on
Yeah. In very general terms, yeah, but I mean, there's another one here on Penta 7. But yes, in general, this is a typical profile that I would expect, and there's nothing unusual about this profile.
You took my next question out of my mouth. Looking at this is the types of figures, the types of numbers that you would expect to see in a results table like this. Is that right?
Correct.
Okay. And while it doesn't say so on the face of the report, are you in a position to deduce that the likely test package that was used for this was Paraplex 16, looking at the loci that we're dealing with?
Yes.
You can't know that to be true, but it's likely to be the case.
Yes, it's highly likely that is the explanation for these loci.
Yes, because those are the loci that Paraplex 16 examines.
Exactly.
All right. Now, before we move away from this report, firstly, can we save it, please, before I forget to do so, and perhaps give it an MFI number? Your Honour, in line with the position taken by the prosecution, we'll await the panel's decision on
Yes, I'm just
admissibility of the
asking,
underlying.
it is a tender, though, and then we'll rule on it later.
In the event that the underlying report is admitted, in those circumstances, we will seek to tender the marked copy, contingent upon that.
Can you restate the numbers for this,
I can.
the location?
This is an extract of P854, page 197, but I'm simply looking to mark for identification a screenshot of these markings, please.
An MFI for P854, page 197, screenshot.
Thank you.
Thank you, Your Honor. Just a moment. Yes, the markings made by witness 4875 on page 197, exhibit P00854, will be registered with the registry number REG 01197 and assigned MFI number 2D 00035. Classification is confidential, I believe.
Thank you.
Thank you. Go ahead.
Perhaps just before we take this off screen, could we please have the bottom right-hand corner in view? And if you could just zoom in on the bold text on the bottom right, please. Mr. Goodwin, this is simply just to confirm that this is one of the reports that you looked at earlier, which you said provided moderate support for identity. Is that right?
That is correct.
Thank you. We can take that off the screen. Pardon me. Now, Mr. Goodwin, we've alluded to on a couple of occasions information that you don't have, and I just want to deal with that, but specifically the impact of that on, or the constraints of that on your ability to analyse or comment upon this body of work. Turning back to those EPGs, just for the sake of clarity, it's right that we do not have a full DNA profile, or otherwise known as the EPG, for any of the samples in this case. Is that right?
Correct. I have not seen any EPGs related to any of these cases.
For all of these cases, all that we have is a document similar to that which we just had on screen, which is a summary report of the testing done.
That is correct.
And it's right that you raised this issue with the prosecution in your report, that you pointed out this absence of EPGs to the prosecution on more than one occasion. Is that right?
I can't remember the specifics, but I think it's reasonable.
Yes. It's right, it immediately stood out to you that this was missing, and you let the prosecution know that this information was missing. And you also let the prosecution know that you would expect that information to be available on request.
Yeah, I can't remember having specific communications with the prosecution on that, but I'm not. Yeah, I can't remember the specifics of what I put in the report.
Mr. Goodwin, it's paragraph 12 of it.
Yeah.
If you'd like,
Okay,
you can refer to it.
I'm taking it as, but I'm just saying I don't have a specific recollection of
Thanks.
it.
Page 12, not paragraph 12.
Yeah. Okay.
For those following,
Okay.
we can have a look at that.
Thank you.
Now, you referred throughout your report to those DNA profiles as being encrypted. Would you agree that the issue with the EPGs, or the DNA profile, isn't one of encryption? We just don't have them. It's not that we have DNA profiles or EPGs that are subjected to encryption. They're absent. We don't have them.
We do not have the DNA profile from which those reports were based.
Yes. I appreciate it's a matter of terminology, but it's not a matter that there's folders in your computer where you have the EPGs.
No.
You just can't decrypt them. You just don't have them.
I don't have them.
Yes. And those EPGs, or those DNA profiles, are something that you as an expert would expect to see in a fellow expert's report. Would you agree?
They would, for a relationship report, they would not typically. I'll take a step back. I wouldn't necessarily expect them to be in a report typically, but they would be there for examination if requested.
You would expect them to be available to you if you request them.
Yeah.
And you would certainly expect them to be made available to you were you to be requested to conduct any analyses.
If I requested them, yes, if I felt it was relevant.
Now, the impact of the absence of those reports, would you agree with me that because you don't have access to those EPGs, that you cannot say, because you cannot examine them, that the DNA profiles were accurately extracted?
I cannot comment on whether they were interpreted correctly.
And you cannot confirm or comment upon whether we are dealing with single-source DNA, as we dealt with before, because you can't look to check. Is that right?
I can't look to check. I wouldn't expect mixed, as we alluded to before, in this type of work, I wouldn't expect mixtures to be a big issue.
And you can't make any assessment of the level, the richness, the quality of the DNA samples that were extracted.
No, I cannot.
And again, in the context of, it was your second report that you had, your follow-up report that you did for the prosecution.
Yes.
You had a phone call with them in relation to that report. And that was in March 23.
Excuse me, you have to say yes or no.
Yes.
My fault.
Okay.
That was in March 23. And one of the things that you explained to them at the time was that you were not in a position to testify about the quality of the DNA profiles produced by the laboratory in question for that report.
That is correct.
And is that equally true of all the other reports?
It is.
Now, in relation to the absence of the EPGs, without those, you were not able to confirm that any of the allelic designations in the test results, in the tables that we have seen, are correct. Would you agree with that?
No, I cannot verify that without seeing the EPGs.
So to break that down a little bit, you can see what their test results are, but you're not in a position to take those test results, go back to the original DNA profile and check that they're right and there's no problems and that all is correct as far as you're concerned. You can't do that analysis.
That is correct.
Your Honor, I'm going to object to this. It's been asked in different formulations multiple times. The witness has clearly expressed his view on what this implication is. I don't know why we need to go over it repeatedly.
Well, we've heard that enough times now, though, so just move on.
What that comes to, before we move on, is you cannot say that any of the results are correct.
Your Honor, that's exactly a question that has been asked and answered before.
Overruled.
You can answer the question.
That is correct.
Thank you. Allele detection thresholds. We don't have access to the allele detection thresholds used by the lab. Is that correct?
That is correct.
Now, what is an allele detection threshold?
It is the amount of, we're talking about peaks on the electropherogram. It is the height which that peak would have to reach in order for us to accept it as a real peak and not an artifact.
So for every allele, you have a certain height that must be met before you count it.
Correct.
And that is the threshold that it must meet for it to be taken into account in your analysis.
Correct.
We don't know what thresholds were used. We don't have access to that.
Correct.
Different labs use different thresholds.
Yes.
We don't know what thresholds were used by any of these labs. Would you agree?
Correct.
And as such, you in your position are not in a, you are not in your position, I'll get it right the third time. You are not in a position to comment upon the appropriateness of any allelic threshold applied.
Correct.
So that's the core data that we're missing, but I just want to deal with some other aspects of the data that you might ordinarily expect to see when being asked to provide an expert report in a criminal matter. The first of those, it's correct, isn't it, that you were not provided with any of the laboratory working notes for any of these samples, is that right?
Correct.
Were you to be provided with laboratory working notes, what information might you expect them to contain?
They would contain when the extractions were carried out, who carried them out, what methodology was used, for example.
And you could gather that information from them?
Yes.
Would you agree that as standard, lab notes can often be around 7 or 8 pages?
It very much
Varies.
very much depends on what we're looking at. For these, I would expect them to be quite streamlined because it's the same process repeated multiple times.
But because of the absence of those notes, you can't examine that information.
That's correct.
We also don't have, or it has not been provided to us, any standard operating procedures that may have applied at the labs doing the work.
Correct.
We also don't have provided to us any information in relation to chain of custody of these bone samples.
Correct.
So we'd have no information about how, with whom, in what fashion, with what precautions, these bone samples made it from autopsy to extraction.
Yeah. I mean, I certainly have not seen that information.
No, well, that makes two of us, Mr. Goodwin. So we have, in addition to that, in the work that's done, scientists don't only deal with the unknown sample, they deal with provided familial samples of those who are hoping to identify a family member.
Correct.
So within the data, we have mention of those family associates who have given samples to be tested
Correct.
against the unknown samples.
Correct.
In terms of those samples, we don't know how, when, where they were taken. We know nothing about where those samples originated from.
I have not been provided with that information.
For the majority of the reports that we have looked at, not including those 4 reports that are the subject of the bigger expert report. Does that distinction make sense? I'm conscious not to name the persons involved.
Yep.
So for all reports, bar those 4 that are the subject of a report, we don't know whether or not any of the testing was the subject of a peer review on the face of the documents.
That is correct.
Just dealing with those perhaps 2 categories of documents. Within the material that you were provided with, we have a collection of summary reports in the format we have seen.
Yep.
And then we have what perhaps we could refer to as a subset of those, which were also the subject of an expert's report signed by 3 persons.
Okay.
Do you recall that additional report in the materials you were provided with?
I can't picture it, but
Perhaps for your benefit, we should just show it
Okay.
to see if it
Yep.
jogs memory. Could we have P855, please? This document, Mr. Goodwin, is actually 2 reports put together
Okay.
in the same PDF. And I'm hoping just the front sheet might jog your memory of it. I can tell you that they are both reports dated in 2004 and both signed off by 3 persons.
okay.
Having seen the front page, do you recall seeing this expert report in the data you were provided with?
I have a vague recollection of it. It was a while ago I looked at it.
Yes. The reason we make that distinction with those reports is because more information is available, would you agree, about those tests in that report than is available for all of the others? Or would you wish to have some time to have a look at it?
I would need some time to have a look at it.
Okay, no problem. Well, perhaps if we can just have a note, I'll make a note of that for perhaps over the lunch break, just to give you the opportunity to have a look at that, and we can deal with it afterwards. Thank you, Madam Clerk. Could we now have U0154164? Mr. Goodwin, as this is being brought up, this is one of the results tables you looked at this morning.
Okay.
And perhaps could we please have Mr. Goodwin's report at page 6 split screen as well? not for public broadcast.
If I can have the ARN of the first document, please.
U0154164. Thank you. And the report now has an MFI 1951. Could we have page 6 of the report on the left-hand side, please? And if we could scroll down so that the totality of question 4 is in view, please. And with the report on the right-hand side, could we increase it so that the first part of the table is in focus? Yeah, thank you. Excuse me. Mr. Goodwin, this was one of the reports that you were asked to deal with in isolation, and you were asked some specific questions about that report.
Correct.
We can see those questions on the left-hand side of our screen. Now, you were referred to these answers by my learned friend for the prosecution this morning, and the answers that you had given to question 4. I just want to deal with this in a little bit more detail with you.
Mm-hmm.
You were asked, does this report appear to adhere to the relevant standards required for such documentation?
Mm-hmm.
And you comment that there are some aspects present that you would expect to see.
Mm-hmm.
But then you say this, however, some elements of the report are unusual. The profiles of the victims and the family members are encrypted, so we can't see which loci have been tested, nor the identity of the alleles. As such, it is not possible to recheck the analysis. When making the calculation of likelihood ratio, a reference database would have to be used to estimate the significance of sharing alleles. This information is not included in this report, so I cannot comment on its appropriateness. So it's right that in answering that question by the prosecution in your report, you have flagged 3 areas that you can identify that are unusual about this report. Is that correct?
That would be correct.
So we have the absence of the DNA profile, the absence of the named loci, and the absence of information about a reference database.
Correct. I mean, I would say given the nature of the identification program, I can understand why the reference database is not on there, and that may not be because that may be contained in an overarching agreement document. But for the other elements, I would agree with yes.
Now, just dealing with this absence of loci and what we mean by that, if we look at the report that we see on our right-hand side, we can immediately see that this looks different to the last report that we were looking at. In that top line for loci, instead of those numbers TH01, DS, DT that we were looking at before, we just have ICMP 1, 2, 3, 4, 5, 6. Is that correct?
That's correct.
Now, that line is where the identity of the loci should be present, as it was present in the last report we looked at.
That would be normal, yes.
But we don't have any of the information about the loci in this report.
Correct.
It has been removed, redacted. It's not reported.
Correct.
We can see that there's 16 loci that have been examined.
Correct.
But we simply cannot know definitively which loci were looked at because this report does not tell us.
Correct.
Ordinarily, you would expect to see the loci on a report such as this to enable you to understand and fully analyse the results.
That would be typical.
And the absence of the loci here prohibits you from re-evaluating or assessing the validity or nature of these findings. Is that correct?
Correct.
Now, what I'd like to deal with on this report, could we zoom in a little bit more, please, just so that we have quite clear, and then if we could go over to the right a little bit. What I'm interested in looking at is ICMP 1 to 6. Please. Right, thank you. Now, you had said in relation to questions from the prosecution a moment ago that these are not normal, the expression you used was not normal names that we see reflected in the alleles. I just want to...
Correct, yeah. The allelic designations are not typical.
So I'd like to explore this a little bit with you. Now, as you just said there, in your opinion, the allelic designations are abnormal.
Yes.
Now, if we can just break down what that means. As we looked at earlier, the allelic designations are these numbers that we're looking at. 4.5, 4.8, 1.6, 1.9, yes?
Correct.
The allelic designations that appear in this report are highly unusual and not what you would expect to see for allelic designations in a results table like this.
Correct.
Now let's look at why they're highly unusual. They are highly unusual because, as you have explained to us earlier, you expect to see STR repeats in multiples of 4 reflected as whole numbers, maybe with a 0.2, rarely, but sometimes, a 0.1, a 0.3, very rarely a 0.4, never over a 0.4.
Correct.
And what we have here is a 0.5, a 0.8, a 0.6, a 0.9, 0.6, 0.5, 0.9.
Correct.
So the majority of the figures that we can see in screen and in the drop-down, highly unusual
Yes.
for that reason.
Yes.
We don't know where these numbers have come from. Would you agree?
I would agree.
You don't know how these numbers were reached by whoever did this analysis.
Yeah. My presumption is it's an encrypted profile.
So this I was going to come on to deal with. You have made, if I could put it this way, an assumption that they may be encrypted. Is that correct?
That's correct.
But you've made the assumption that they may be encrypted because you can't explain these numbers. Is that right?
That is correct.
One possible explanation that exists is that they could be encrypted.
Correct.
You don't know that they are, in fact, encrypted.
I do not know that for sure, but they are not. It's not a normal SDR profile.
So if we go then at the first part of that the first part, perhaps it was the second part of that sentence. The starting position is, this is not a normal SDR profile.
I would agree.
It's highly unusual.
I would agree.
You have no information about any of the surrounding work, methodology, underlying reports, anything, to assist you in figuring out why it's highly unusual.
I would agree.
It might be encrypted. If it's encrypted, and I appreciate both of us are taking that on a speculative basis, because neither of us can say that for sure. If we speculate and say, well, it could be encrypted, we can't know the nature of that encryption.
No.
We couldn't know what the encrypted numbers mean.
Not without reverse encoding it.
We'd be shooting in the dark to guess what encryption or what code could possibly have been applied to these.
We cannot ascertain the underlying profile.
No. So all that we can really say about this report is, on its face, it's highly unusual and we have no idea why. We can't say why.
Yeah.
Have you ever seen numbers like this appear in a report like this?
No, I have not.
And perhaps just for the benefit of those following, could we just look at this? Could we keep the right-hand side, please? And could we take down the report for now, please? And can we get back up P854 at page 197, please? Split screen. And can we zoom in, please, on the top right? Mr. Goodwin, this is the report we looked at previously.
Yes.
That you had said contained numbers of the kind. I'm sorry, can we go to the left? Thank you. A little bit more to the right. So we have a few more in view. Thank you. We're looking at, on the left-hand side, the report that we looked at earlier, which contains the types of results you may expect to find. And on the right-hand side, we're looking at a report with highly unusual findings you would not expect to find. And we can see here the very visible difference between these two sets of
Yes.
results. Is that right?
Correct.
Thank you. Thank you, Madam Clerk. Can we please take down the left-hand side report that we've just looked at? And can we please have back up Mr. Goodwin's report, please, at page 11 in its place? Mr. Goodwin, while that's being done, in your preparatory session, you had mentioned to the prosecution that you understood at the time that it was the ICMP's practice to encrypt.
That's correct.
How and when did you come to know that or understand that?
Just from working in the field for the last 20 or so years. I know it had been raised in the past.
Yes. And when... Wait for that. Page 11, please. Would you agree that when we're looking at reports such as that on the right-hand side that we've been looking at with the unusual allelic designations, that there is or there exists a valid reason to query the nature of those results because they are not usual?
Yeah, they are unusual reports.
Yes. And because they are unusual, would you agree that that warrants or you would advise there to be further exploration as to how those results were arrived at because it's not clear?
I mean, certainly knowing, understanding what encryption was used would be helpful.
Certainly. Or perhaps it may be that encryption is not the reason why they appear like that. Because we can't know that, you or any other expert would want to know how those numbers were designated.
Yes.
Thank you. We're at page 11. Thank you. Now, standing back a little bit, reports of this nature, as a collection that you were shown, not including those 4 that are in the report. The SPO in your letter of instruction asked you, you'll see here actually, we have it on page 11, you have this collection, you'll see of victims' names.
Yeah.
So we have for all of those victims listed there a report that looks like the one we have on the right-hand side.
Yeah.
Now, you were asked some generally applicable questions that apply to all of those reports.
Yeah.
And they were whether the reports, so dealing with each one, appeared to adhere to the relevant standards required for such documentation, and whether such reports contain conclusions supported by information set out in such items. And we can see at the bottom of page 11 on our screens that you answer that question in the collective at the outset.
Yes.
Is that correct?
Yes.
So when we look at your answer here, is it right that your answer applies to all of those reports listed in the victim section there? But it would equally apply to the report we're looking at now, which actually isn't in that list.
Okay.
Would you agree?
Yep.
So all of the reports that look like that, the chart, one-page charts.
Yeah.
Okay. So just in terms of how you dealt with the first question, which is whether or not the reports appear to adhere to the relevant standards required, if we could just look at your answers here. One of the observations you make is that these are reports in summary form. Is it right then to understand that, in your opinion, these are reports, they're just summaries of reports?
I believe this would be the report.
Yeah. So in your opinion, it's an expert report, it's just a short one?
Yes.
Now, we can come on to see the difference between a lengthier expert report that can be served like the one we brought up on screen a little bit earlier. But if we could please turn your report to page 12, where you set out your answer to this question. Now, here we have your response to this collection of reports collectively. And would you agree it's right that you set out here 3 elements that you identified in the reports that are not standard, in your opinion?
Yes, I would agree.
And in short form, because we have covered a lot of this ground, firstly, no information is provided on the methods used for the analysis of samples, which would normally feature.
Yep.
Secondly, DNA profiles presented in the reports are encrypted, and this prevents re-evaluation of data or comparison with DNA profiles. No statistical re-evaluation is possible. And number 3, one element that is not very clear on the reports is who has signed off the reports. There's a signature, but it's not possible to identify.
Correct.
And as you've already explained, it's right, isn't it, that these three concerns apply to all of the reports that come in this form that we see on our right.
Correct.
And on top of those concerns, would you agree that we have 2 additional concerns that apply? One being the unusual, highly unusual allelic designations. Is that correct?
Yeah, I would say that. I mean, I am confident that is through encryption.
Yes.
That itself is unusual.
And secondly, the encryption of the loci.
Yes.
Yes. So we can add 2 to that list as well.
I believe the encryption is in there already on point 2 that their profile. Well, I'm presuming encryption.
Yes, I had taken you to mean, and am I incorrect in my understanding that when you had said encryption of the profiles, you weren't referring to the encryption of the EPGs?
No, I was referring to the encryption of the data that we see in these reports.
So could we then add to the list absence of EPGs?
Yes.
Okay. Just notice we have all of it in one place. All right. Now, in terms of this report specifically, so coming away from these reports as a collective,
Yes.
and back to this one we have here. Could we please go to page 6 of your report? Because as we dealt with earlier, and I'm interested in question 3. Yeah, great. As we've dealt with earlier, you were asked some specific questions on certain reports and then grouping type questions on others. But one specific question that you were asked on this report was, does the information contained in this report support the conclusions reached therein? And I just want to look at your answer in relation to this. So if we look at the first part of your answer, it reads, as far as the report can be interpreted, the results support the conclusion and the calculation is correct. Would it be fair to put it perhaps in this way, that if the results recorded in the report are accurate, then it is correct?
That would be reasonable.
Yes. Because would you agree that there needs to be a caveat within that answer somewhere to take account for the fact that you can't check?
Yes.
Yes. And you give it to us in a certain way at the beginning, as far as this can be interpreted.
Yes.
Yes. So on its face, it looks like the maths is correct, but we can't know that it is.
Yeah. We cannot. The end value is reasonable given the family that's been tested and the underlying testing that we understand is happening.
Yes.
We can't test the maths.
Yes. Looking at that proposition, because you had mentioned something along those lines earlier about what you might reasonably expect a statistic to look at. Can we just look at that briefly? When you are looking at testing familial members against unknown samples, there are certain ranges of results that you might expect to find in case of positive matching. Is that right?
That's correct.
So when you speak of results being reasonable or within the range of reasonable responses you might expect.
Yes.
What that simply amounts to is that's not an unusual result. That's within the range that we would expect in this type of test with these types of relationships being tested. Is that right?
That's correct.
Okay. And you also give the caveat in that answer in any event if we look down, that given the format of the report, other than checking the profiles are compatible, you can't scrutinise it.
Correct.
And then I think it's the last question. Question 5, which doesn't appear on our report. It might be just over the page, please. Thank you. You were asked, does the conclusion in this report denote a low or a high likelihood that the deceased person was accurately identified through DNA analysis? And you give a short response in relation to that answer, which is, I would class this as extremely strong report for identity. Would it be more accurate to, if I was to rephrase that to say, a finding of 99.999949 is extremely strong support for identity?
Yes.
That finding is extremely strong support.
That is what the basis of my statement in question 5.
Yes. But you are not in a position to tell us that this analysis, this report, in fact, gives extremely strong support.
That's correct.
Thank you. I think we're finally done with our report on the right. Could we please replace the report on the right with SPOE 000726778 to 0007275 red. And I'm looking for page 14 of the PDF, please. ERN ending 2691. Again, Mr. Goodwin, it's one that we've looked at this morning already.
Yes.
Prosecution. Thank you. Could we please zoom in? As before, thank you very much. And could we please have page 9 of Mr. Goodwin's report on the left? And could we scroll down, please, to where that victim's name is at the bottom? Thank you. All right, this again was one of those reports that you were asked to look at on an individualised basis as opposed to as a collective, is that right?
Correct.
And that might be because it's right, isn't it, that in the conclusions of this report, there is mention of or reference to a mutational event.
That's correct.
Can you explain to us what a mutational event is, please?
Yes, a mutational event is where the STR passed on from the parent to the child changes as a process of mutation. So the child would receive a slightly different variant of the STR or the allele than the parent contains.
And you were asked to deal with that. Again, it's a question like the ones we've dealt with earlier. You have explained to the prosecution that there are various approaches to incorporating mutational events into findings like this. Is that right?
That is correct.
There's different ways of doing it, depending on the lab or the person doing that work.
The lab would have a procedure, but procedures would vary between laboratories.
And then again, you have not been provided with the procedures that were in place for dealing with this mutational event by this laboratory.
That's correct.
And as such, you cannot confirm whether or not the manner in which this mutational event was dealt with would be of the standard or done in a way that you would approve of or confirm is correct.
That is correct.
With this report, you were also asked those 2 overarching questions, like you were with the other reports. And are we correct to assume that the 5 points that we've looked at apply here?
They do.
One exception being, if we look at this, we actually do have the loci for this one.
Yeah, they vary between whether loci are given depending from report to report.
Of course, you'll need an opportunity to have a look at it, but I believe we're dealing with 14 that have no loci.
Okay.
And again, just before we move away from this, looking at the allelic designations, both for the unknown reference sample at the top, but also with the various familial references that we have, would you agree that, again, reflected in this report are these highly unusual allelic designations, 0.9, 0.7, 0.9, 0.9?
Correct.
Correct. And the evidence that you gave in relation to the report we previously looked at would equally apply in this case?
Correct.
Thank you. And again, and this question applies to all of these reports. Because of these issues, because of the absence of information, for this report, like any other, you cannot confirm the accuracy or the reliability of these conclusions.
That is correct.
Could we look at one more maybe, please? Could we have, sorry, just gonna bear with me, I'll get my bundle. Could we look at SPOE 00291803, please? Mr. Wood, I'm not going to take you through all of the reports that you have, because we, of course, have over 20. But I'd like just to deal with one more,
Sure.
just so that we're confident that we have really explored the various issues that apply to these summary reports. And we can have this full page, thank you. We don't need the other one anymore. Thank you. Now, Mr. Gunn, is it right that this is another one of the summary reports that you were asked to look at in the course of your work?
That is correct.
And would you agree that, again, all of those weaknesses that you identified in your report apply equally to this?
I would.
But we have, again, the two new issues that we're looking at. This one is a good example, again, of encrypted loci at the top. Is that right?
Correct.
And again, highly unusual allelic designations in the body.
Correct.
Thank you. And perhaps it might be something that you could look at for us over the lunch break. I'm conscious, I don't want to bring you through all of the 20-something reports that we have. But the proposition I wish to put to you is that for all of the reports, except those 4 that are the subject of their separate report, these issues arise.
Yes.
I don't know whether or not you'd be confident to agree to that without having the opportunity to check, but you must have if you wish.
No, I would agree that for any that display this unusual allelic pattern, that they are highly likely to be encrypted. I mean, one thing to point out as well is they all have a protocol key again, which is something I would expect in encryption. So I would agree with your summary.
Okay, thank you. Now, the other, we can take that down, thank you very much. The other broad overarching question that you were asked about these reports,
Yes.
we've looked at one of them.
Yeah.
The other one was whether or not the reports contain conclusions supported by the information set out in such an item. And for your benefit, perhaps we should have your report, page 11, just in case you wish to refer to it. The report is 1951. I'll simply bring it up in case you wish to refer to the answers
Sure.
that you had in your report. But in short, if you would allow me to summarise your response to that, is that you firstly do say, you reiterate in that response that the DNA profiles are encrypted, you can't do a full review. That's recorded there, yes?
Yes.
But you do go on to say that the conclusions seem appropriate and seem reasonable.
Yes.
Yes. Now, that is an answer that's reflected in the report. But just to clarify exactly what's meant by that, and while it may seem obvious, you are not saying conclusively these findings are reasonable and these findings are in fact appropriate.
No, I cannot do that without seeing the underlying data.
Exactly. And were you to be provided with that, you could, of course, do that analysis for us.
Yes.
Thank you. And we've already gone through, and I don't intend to repeat, the information you would require to do that and what's missing. Your Honour, I'm conscious that my client has stepped out of court. Would Your Honour allow us 10 minutes so we can identify the cause of the issue, please?
It's not a big issue, yes.
Thank you.
Break until he can come back.
I'm grateful, thank you.
So we're temporarily adjourned. You may leave the courtroom with the usher. We're adjourned for just a few minutes. Stay close.
All rise.
Be seated, please. Please bring the witness in.
Your Honour, I'm told I'm almost hitting my 2-hour point. But with Your Honour's leave, I will finish by the lunch break, and I understand other teams won't take their allocated time. Thank you.
All right, witness, we will continue with the questions.
Thank you for your patience, Mr. Goodwin. Could we please have Prosecution Exhibit 854 at page 239? Mr. Goodwin, what I'd like to do now is come away from that larger collection of documents and look at one of the 4 reports in this subset, as I've been calling it, which are the subject of an expert report. Does that make sense?
Yes.
Great. And I'd just like to look at one of the summary reports contained within that. Oh, that doesn't look right. 239, please. It should be another chart. Now, this is a report that you have not yet seen today.
Okay.
Again, it should not be for public broadcast. You can see the possible identity name, so you can see it's not one we've already examined. The one that we were looking at from this subset of 4 earlier concerned a different possible identity. What I simply wish to do with this is, again, to reinforce the difference between this report and the 3 we've just looked at.
Yes.
Circling back to where we began. If we look at this report, we see named loci, would you agree, at the top?
Correct.
Allelic designations within the range that we would expect.
Correct.
We have a rogue 0.2 in there, but we would expect to see that.
Exactly.
And this is the type of result that you would expect to see. Big whole numbers, no decimals.
Correct.
And again, please say if you would like the time to consider the other 2 reports, but would you agree that the one we've looked at the beginning, this one, and the other 2 that are dealt with in that expert report, all come as you would anticipate them to look like? Would you agree?
Yes, I would agree.
Thank you. Can we scroll to the bottom of this, please, so we can just see the bottom? I'm going to look at another difference in these. One other difference, would you agree, Mr. Goodwin, with these 4 reports, as compared to all the others, is that we can see at the bottom here, initial review, signature and date, final review, signature and date, and general review, signature and date.
Correct.
On all of the other reports, and again, if you need time to check them, please say so, they only contain one signature, pardon me.
Okay. Yep, I'll take that as correct.
And in none of those reports is the identity of the person signing the report clear.
Correct.
But here we have 3 dates in 2002 and we have 3 signatures. In your opinion, does that indicate that a peer review had been conducted?
This would suggest that that is based on peer review, yes.
So where we have more than one signatures indicating more than one review, we can likely deduce from that that report was likely subject to peer review.
Correct.
Could you please explain what peer review is?
Peer review is when a second person will independently check the results to make sure that they agree with the presentation of the data and the conclusions presented.
And that is not the case for the remaining reports.
That is not evident on the remaining reports.
Yes, we can't know one way or the other. Now, in relation to, pardon me, no, we've dealt with the dates, thank you. That report can come off screen, thank you very much. Now, I'd like to turn to this expert report that we've mentioned a couple of times.
Yeah.
Could we please have P855? And again, not for public viewing, thank you. And if you could just scroll down to just where the body of the report begins, please. So we can see here testimony requested. So the instruction, we might say, given to the authors of this report. And we can see here that the ICMP notes that it was asked to provide expert testimony on DNA analysis, which ICMP had performed for UNMIC on biological samples provided by UNMIC.
Okay.
So we can see that's the report.
Yeah.
Now, it's right, if we can scroll down so you just have an opportunity to refresh your memory in relation to what this report looks like. It's right that this report does deal in some detail with the methodology deployed by the scientists in this case. If you could go down another page. We see here. So it explains the methodology that was used in the tests that were performed.
Yes.
So it's right, therefore, that for those independent 4 tests, we have a little bit more information than we otherwise would have as to the methodology used.
Yes.
And we also have, at the end of this report, the signatures of the 3 persons responsible for providing that information.
Yes.
So you are in a position to have a little bit of a better understanding as to what work was done on those 4 test results that we've been looking at as a subset.
Yes.
Those 4 test results being the only 4 that present as you would expect.
Yes.
Now, while that's the case,
The interpreters kindly ask the speakers to slow down when asking questions. We really need a pause between question and answer. Thank you.
yeah, yes,
You're being warned again about how fast you're talking.
I've been warned to my left. I'm conscious of it. Thank you. Could we go to page 5 of this report, please? Mr. Goodwin, we've been asked not to mention the possible identities by name, but I just want to deal with one of the possible identities. As you will have heard me refer repeatedly to 4 reports contained within this. This is a 5th. But would you agree that this sample, and we can see at the top here the name of the possible identity,
Yeah.
and perhaps if we can refer to it in this way, it is from an unknown bone sample marked NN 986. So perhaps if we refer to this as the report for 986. Would you agree that for sample 986, we don't even have that underlying chart that we have for all the other reports?
Certainly based on what is on the screen, that is true.
And you have not otherwise been provided with that?
I do not believe I have, no.
So for this sample, we have no information about the type of testing that was used, is that right?
Based on what is here, yeah, that's correct.
We cannot know which loci were tested or what allelic designations may or may not have presented themselves in any test. Is that right?
Correct.
We cannot know the nature or number of potential familial relationships tested.
Correct.
And we cannot know whether or not there is any data contained within that analysis that would give you cause to query any conclusions reached.
Correct.
We have no information whatsoever about how the conclusions that are recorded at the bottom of that page were reached by the scientists who conducted the work.
Correct.
And as such, you are not in a position to comment upon in any meaningful way and certainly not confirm the veracity of any conclusion given.
Correct.
Thank you. In addition, in this report, again, please say if you'd like time to consider it more fully, but from what you remember from considering this report, would you agree that this report also does not contain any laboratory notes?
Correct.
It also doesn't contain standard operating procedures.
Correct.
And it also doesn't contain any mitigation mechanisms put in place to deal with contamination.
Correct.
So that information that we're lacking for all of the rest of the reports is also missing from this report.
Yeah. I should say, I mean, I would not expect that information to be presented in a report.
Yes.
I would expect it to be available if asked for.
Yes, and what you would expect it to have is methodology and results, which it does have.
Yeah.
Yes. It reads, and apologies, I don't have the page reference for this, but Mr. Goodwin, if you'd like to read it for yourself, please let me know and I can pull the page reference. But in this report, it says that the DNA profiles obtained from the bone samples listed in this report were submitted by the respective DNA laboratories to the Identification and Coordination Centre in Tulsa.
Mm-hmm.
And they were entered into the database and a search was performed. When a match between a DNA profile from a bone sample and reference blood samples occurred, a DNA match report has been generated.
Mm-hmm.
So would you agree that's the explanation of the steps that the scientists carried out when performing this work?
Yeah, that would be an understood pathway to come to the conclusion.
Yes. It's right that you were not given access to the database used.
Correct.
So you were unable to verify the information that was used to run the searches, and is that correct?
Correct.
And you're unable to verify the results of any of those searches.
Correct.
I'm just thinking, Mr. Goodwin, about how to deal with. We have another situation where I'd like to ask you about an identified individual. Before we take this off the screen, one final question on this report and the 4 charts that we do have that underlie it. While they are in keeping with what you would anticipate seeing or would expect to see in terms of reports like that, again, you cannot confirm that they are correct and you cannot confirm that the work was reliably done.
I can.
Now, I'm going to do it this way. Could I please have P1951 at page 5, please? Oh, I don't mean that. Yeah, pardon me. I'm being corrected. 1952, please, the letter of instruction. Mr. Goodwin, I'm just going to use this to identify a name for you to stop us having to go into private session to do it. It might just be easier. So if I could have page 5, please. Thank you very much. Now, Mr. Goodwin, if you could just please look at that top line. You see where it says victims?
Yes.
And we have a number of listed victims there. And do you see the last named victim in that list?
Yes.
Would you agree with me that while he appears in that list of victims, there are in fact no DNA reports concerning that possible ID?
I have not looked. I don't believe I've looked at any DNA reports related to that individual.
I'm grateful, thank you. And if you would like to do so, we will be breaking at 1. So of course, you'll have the time to double check that. But I'll suggest to you that there are no underlying DNA reports for this possible identification. And
Yeah.
tentatively, you would agree with that for now.
Yes.
If you could confirm that over the lunchtime, I'd be grateful. Thank you.
Your Honour, I would rise to remind counsel of instructions previously given by the judge that the counsel's role is not to task the witness, expert or otherwise, to undertake any particular activities. Counsel can ask questions now, but the witness is not here to receive homework.
Sustained.
I'll ask you again at 2:30.
The name, it does not trigger any memories of DNA
Yes.
profile.
Are you confident in your response that you have not seen any DNA report for this person named?
I'm reasonably confident, as confident as I can be.
And I'm sure if we're wrong, we'll be corrected by our learned friend for the prosecution over his own lunch break. All right, if we just look at then, just standing back and looking at the difference in these two batches of reports that we have, it's right to say that all of the reports that you've looked at, bar that one that we're not dealing with today, that was the subject of a second report, they all originating from the ICMP.
Correct.
However, 4 of the reports on their face vary significantly from the rest of the reports that we've been looking at. Is that right?
Correct.
And you're certainly not in a position to explain to us why that difference exists.
Correct.
And what I'd like to do is just look at some differences that we may be able to find in those two subsets, and some differences that may exist. Now, for the 4 reports we've just looked at, that are the subject of the report that we still have on screen, on the right, it's right that one difference for those reports is that we know that a court, the ICTY, asked the ICMP to provide expert testimony on the analysis that they had conducted for those samples. Is that right?
If it says in the report.
Yes,
yeah.
perhaps if we go to the first page, I thought we had looked at it. But
I agree.
The second difference is that all 4 of the reports dealt with in this expert's report are dated in 2002. However, all of the other reports are dated later in 2005, 2006, and some as late as 2009. Would you be in a position to confirm that date disparity?
I would have to double check the date. I mean, I can't remember the dates of the individual reports, but yes.
It sounds accurate.
Yes.
And another difference on the face of the reports is that we can see evidence of what appears to be peer review for the 4 reports.
Yes.
Subject to the report. Thank you. Now, Mr. Goodman, I'm hoping you could assist us with a different type of document, and it's not one that we've looked at yet today. Could we please have SPOE 000 68661, page 1. Thank you very much. Mr. Goodman, this is what purports to be a confirmation of identity document issued by UNMIC. Can
Okay.
you see that?
Yes, I can.
Now, there should have been at least one of these types of documents in the data set that you received. Do you recall seeing a document like this before?
I don't recall it, but that doesn't mean I didn't see it.
You won't have seen this one.
Okay.
Could we just scroll down, please, Not that far. If we can just have the date toward, yes, perfect, thank you. All right. Perhaps if I could give you a moment just to reorientate yourself with this type of document before I ask you some questions on it and allow you to read it.
Okay. Okay.
Ms. Jordan, this is another form of DNA evidence that exists in the evidential matrix of this case, if I can put it that way. But it's not something, or not a type of document you've been asked to comment upon specifically by the prosecution.
Yes.
But I'd like to ask for your assistance with it. First of all, can we just see at the bottom, it's slightly obscured in the English, the stamp, but we can see it's signed and we can see the name of the person who signed it.
Yes.
I don't believe there's any reason why this needs to be confidential, unless I'm corrected. No. There's a Mr. Barabar who
Yep.
signed this off. And we can see that he's head of office.
Yes.
Now, you may not recall, but I don't believe we looked at the page, but we can know, or we can see, in the report that we had looked at earlier, his expertise is as a forensic anthropologist.
Yes.
Yes. You would agree with me that a forensic anthropologist is not by default a DNA expert. They are traditionally separate expertise.
Yes, they are forensic anthropologists. Their expertise is anthropology.
Yes. Not DNA analysis like yourself.
No.
No. They are distinct and don't traditionally cross over, while they may well work together.
In cases like this, they would typically work together, so they should know about each other's profession, but not be acting as a DNA analyst or a DNA analyst as a forensic anthropologist.
Not be straying into giving opinions or conclusions into a field that is not their own. Like you wouldn't stray into giving conclusions or opinions about anthropological expertise.
Yeah, I wouldn't give opinion on anthropological expertise, but I may sign off a report which contains anthropological expertise if a forensic anthropologist has contributed to that.
Yes, and we've actually seen a report just like that. The report that we looked at previously is a report conducted by 3 different experts who came together to share their individual expertise to do a composite report, and each 3 experts signed off. Yes. So in that setting, of course, you would work together on a report, but you would not consider yourself best placed to exert an opinion independently on anthropological conclusions.
No, I would not.
Yes, and the reverse is also true. Could we have the document, please, more centred again? Thank you. What I'd like to do is just run through some quick questions about the limits of the information that we have here. Would you agree that this document purports to provide, as it says there, a positive identity from the sampling that was done?
Yes, that would be the conclusion.
It says the DNA results obtained from the bone or tooth samples were consistent with the listed familial relationship.
Correct.
So it purports to suggest that whatever testing was done resulted in a positive match conclusion.
Correct.
To an unknown familial relationship.
Correct.
Just looking at the limitations of a document like this, and this is ground that we've covered before, but we have not dealt with a document such as this before. But just to confirm, we cannot know where or when this testing was done from the face of the document.
Correct.
We cannot know the methodology deployed in extraction.
Correct.
We cannot, unless provided with it, know anything about the EPG.
Correct.
We cannot know anything unless provided with it of any allelic threshold information.
Correct.
We cannot know anything about contamination mitigation procedures that may have been put in place.
Correct.
We cannot know that the DNA profiles are sound, and that cannot be checked by anybody.
Correct.
We don't have the test results in this certificate from any multi-mix that may have been used.
Correct.
We can't know what multi-mix would have been used
Multiplex.
Plex, pardon me.
That's
The
okay.
fourth time I'll get it right.
Multiplex.
The multiplex has been used.
No, we do not. From this, we do not know what DNA has been analysed.
We don't know what sample was used, whether it be bone or what type of bone, or tooth, because we see here the report doesn't even specify that, from the bone or tooth. In the italicised, indented paragraph, line 2.
Yeah, no.
So we don't even know what part of the skeletal remains were tested.
Based on this, no.
No, simply based on the face of this document. We can't know the quality or the richness of any DNA sample looked at.
No.
We can't know whether or not any DNA sample examined was mixed, partial, or composite from this alone.
From this alone, no. Although I would expect a mixed profile not to be entered into the analysis.
But we cannot know.
You cannot know, but it would be highly unusual to use a mixed profile to search for other DNA profiles, because it would be very difficult to do that.
We don't know how many alleles were tested.
We do not.
Or loci.
I mean loci.
Loci, pardon me, yeah. We don't know how many loci were tested. We cannot tell if it was peer-reviewed.
That's correct.
We cannot know whether or not any mutations were found.
Correct.
We cannot know the allelic designations.
Correct.
We cannot know if they are highly unusual, like we saw in the other reports.
Correct.
We do not know if a prior probability was applied, and if so, what it may have been.
Yeah, well, no statistic is given, so I think we can assume, well, we can see that, no statistic is given, so there's no indication of prior or posterior probabilities being used.
No indication of such, but cannot confirm that that may have formed part of the
Sure.
analyses.
It may have formed part of the opinion.
Dealing with the expression consistent with. Consistent with is not an expression that's used on Hummel's chart, is that right?
Hummel's chart is not something I am overly familiar with. I've commented on the report, but consistent with is not something that we usually use in forensic reporting.
Yes. Well, let's step away from Hummel's chart. Consistent with is not used in forensic reporting, because would you agree it's not a very helpful term, because it could mean such a broad...
Exactly. It doesn't imply, given it can be consistent with without being... It gives no value.
Yes. Something...
It gives no indication of how strong that consistency is, if you want to put it like that.
Because a finding could be consistent with a result, but that result could still be highly unlikely. If it's not inconsistent with.
Yeah, I think the problem with using consistent with is it just doesn't give any indication as to the strength of that consistency, nor the basis of it.
This could be referring to a 50% match or a 90% match, and we wouldn't know.
In principle, yes.
Yes. And obviously, for your purposes, for this area of expertise, the difference between a 50% match and a 90% match is significant.
Yeah, I mean, just on terminology, 50% match, 90% match doesn't make a lot of sense either.
Probability.
Probability, yeah. A 50% probability versus a 90% posterior probability. Yeah.
Posterior. If I can rephrase my question to 50% posterior possibility to 90%.
Yeah.
Either of those figures could be consistent with.
50% wouldn't be consistent nor inconsistent in the way that I would interpret it, but yeah, 60% could be.
Yeah.
No, you're right.
Could mean anything. It could mean a wide variety.
There's a wide range of strength of evidence that could relate to.
Yes. And you're not in a position to rerun the analysis with a document like this.
No.
You can't know whether or not there's cause or reason to doubt these findings without the underlying material.
No.
And you cannot know whether or not there's any anomalies within the results.
No.
And we cannot meaningfully ask you to comment on this because there's a complete absence of where this conclusion came from.
Yeah, I think that'd be reasonable.
Yes. Finally, if Your Honour would allow me 5 minutes, I could finish. No. 2:30.
We have to give the court reporter and the interpreters a well-deserved rest. I'm sorry, you'll be excused from the courtroom for an hour and a half for lunch. We'll see you back here at 2:30.
Okay, thank you.
Your Honour, just to update you, my time estimate was 1 hour, but a lot of my questions have been covered. I don't anticipate being longer than about 15, 20 minutes.
Thank you. Anybody else want to weigh in on time?
I doubt I'll have any questions.
And I doubt I will have any questions, Your Honour.
All right, fine. We'll see you all at 2:30. We're adjourned until then.
All rise. All rise.
Be seated. You may bring the witness in. You may be seated. Ms. Rowan?
Thank you, Your Honour. Mr. Woodrum, welcome back.
Thank you.
I just have a handful of questions left. Your preparatory session that you had with the prosecution last week over Zoom, do you
Yes.
recall that?
Yes.
I just want to deal with one comment that you had made to the prosecution in
Yes.
the course of that session.
Yes.
You mentioned to them, and for those following, it was page 1, paragraph 4 of the note we have of that conversation. You asked them whether or not, in your status as their witness, should mention certain weaknesses during your testimony. Do you remember seeking clarification on that from the prosecutor?
Yes.
Could I ask you, when you asked that question of them, what weaknesses did you have in mind?
The data that I presented in the report in terms of likelihoods was based on analysis that I would think ICMP probably carried out similar analysis. So prosecution touched on one element of that this morning when asking about population and substructure. And so incorporating population and substructure would reduce the likelihood ratios where I've calculated likelihood ratios. Another element is that the Powerplex 16 has four loci, the two pairs of loci on the same chromosome. So in some circumstances, one of those is discounted as evidence, which again reduces the overall likelihood ratios.
Just dealing with that last point, as we haven't dealt with that before, could you just spell out in a little bit more detail what impact that may have on a result?
Yes, so the fact that two loci are situated on the same chromosomes means they are physically attached, and therefore they may be not inherited entirely independently. They are located a significant distance apart on the chromosomes, which means that recombination between them is common during meiosis, if you want to be technical.
Yes.
But to err on the side of caution, that can be taken into consideration, that linkage between them, physical linkage between them.
And you mentioned that that is something that can occur on the Powerplex 16 testing system.
There are two pairs of loci on the Powerplex 16 where that applies.
And the reason that that's relevant to this case is that while it is not indicated on the reports that we have that that is the test used, you can deduce from the tests where the loci are named that that is the likely test that has been used.
Correct.
And that is why that concern of yours would be relevant to the testing that we've seen.
Yes.
I'm grateful. Could I ask you now, having given evidence for a morning, confident that you have had the opportunity to go through all of the weaknesses as you see them in the underlying data?
Yes, I believe so.
And then finally, just on this point, when you raised that question with the prosecution, did the prosecution ask you to elaborate or explain to them the weaknesses that you saw?
They did not at that time, no.
Thank you. So just to conclude, Mr. Goodwin, with my questions for today, it's right that what you've done is assisted this court to the best of your ability to answer all of the questions that you were specifically asked to answer.
I have tried my best to do that.
And you have had a data set that's been provided to you that you would agree was somewhat limited.
Yes.
And all of the answers you've given are based upon the data as you see it, with all the limitations that come with that.
Yes.
Through no fault of your own, that data set is limited. But if we could summarise it in this way, because of the limitations, as we've gone through over the course of the morning, on the lack of information and the resultant inability of you to retest or examine, the position simply is, would you agree, that you cannot confirm any of the conclusions in any of the reports that you have seen to be in fact accurate or reliable?
I cannot compare them to the original data. In order to do that, based on the data provided, I would stand by the sort of general conclusions that I've made in terms of what this is making the assumption that what ICMP provided is correct.
Yes, you're in a position to look at the reports on their face and assume that they may well be correct.
Yes.
But you cannot test that underlying data to confirm for your own purposes that it is in fact correct.
Objection, Your Honor. Asked and answered now, before the break, multiple times at that stage.
Overruled. Please move on if you don't have any other questions.
Perhaps if we could just have the answer first.
What?
If Your Honour has overruled the objection, perhaps we could have the answer.
You can answer the question.
Would you like me to repeat it?
Please do.
924. You cannot test the underlying data. No, I'll read the full question. You're in a position to look at the reports on their face, which you confirmed you're in a position to do, and you've also confirmed you can assume them to be correct. But the question that was objected to was you cannot test the underlying data to confirm for your own purposes that it is in fact correct, that being distinct from assuming it to be.
Yeah, I would say I cannot evaluate the underlying DNA profiles that have made up the reports.
And as such, you're not in a position to adopt those conclusions as your own?
No, I can only comment on those as belonging to ICMP.
Thank you, Mr. Goodwin.
Mr. Tavicoli?
I have nothing to add. I simply adopt the cross-examination of my learned friend.
And the same for us, Your Honour. Thank you
All
very
right.
much.
Mr. Ellis?
Your Honour, just a moment, if I may. Yes, good afternoon, Mr. Goodwin.
Good afternoon.
My name's Aidan Ellis, and I'm representing the fourth defendant, Mr. Jakub Kuznici. I don't want to go over topics that you've already explained in the course of the day. I did want to ask you a small number of questions about just two topics. The first is prior probabilities,
Yep.
and the second would be the adjustments for population substructure.
Yep.
Okay. In terms of prior probabilities, have I understood correctly that in the DNA reports, where we see a conclusion expressed as a percentage, that reflects a combination of the likelihood ratio with a prior probability?
That is correct.
And so you've explained, I think, in your first report that if you had 100 people killed in, say, an air crash, then the prior probability that any specific remains match a particular person would be 1 in 100.
Simplistically, yes.
And then your assumption would be in a post-conflict situation that one might base the prior probabilities based on the approximate number of missing people from the
Yes.
conflict. Is that right?
That would be common practice.
And in simple terms, the more missing people that you have, the lower the prior probability becomes.
Yes, that's correct.
And that ultimately would result in a lower percentage conclusion being expressed.
That is correct.
And so determining the prior probability is something that has to be based on factual information about the conflict. It's not a question of DNA expertise as such.
It's not based on DNA expertise. And so, yeah, it is based on the information known about the conflict, or the scenario that you're working with.
And so if we could have an example on screen, please, which we've looked at a couple of times today already, and I think it's not to be broadcast outside. It's U15-4164, please. If we could scroll down a little so that the conclusion can be read. What we see there is that it simply gives a percentage and says when using prior odds of 1 in 3,000. Is that?
Yes,
do you see that?
That's correct.
And it doesn't tell us how that figure of 1 in 3,000 has been arrived at, or indeed who has determined that that's the appropriate figure to use.
It does not on this report, no.
No. Now, if we could go to a different report, please, which would be SPOE 000-72678 at page SPOE 000-72691.
Is it red or red 2?
For these purposes, I think either could be used. And again, if we could scroll down so that the conclusion can be read. Am I reading it correctly, Mr. Goodwin, that we now have a report using prior odds of 1 in 1,300?
And that is what is stated here, yes.
And again, there's no explanation here of how that 1 in 1,300 figure has been arrived at, is there?
Not that I can see, no.
And indeed, based on the information you've been provided with, you wouldn't be able to tell why some of these reports use 1 in 3,000 and some use 1 in 1,300.
I'm not sure on the chronology of the reports. It is again accepted practice that the prior probabilities can change as the identification program proceeds and there are fewer missing people. But it may be on, I presume it's on updated information, or being more conservative with 3,000.
Quite. But without an explanation, that's an assumption.
Yeah, it's an assumption, absolutely.
Yeah. And of course, if the 1 in 3,000 figure had been used for these reports, then the percentages would come down, wouldn't they?
Yes, I mean the impact it would have on this particular case is minimal because the likelihood is so high. It would probably not change the percentage figure with the 99.99999%. It may change it slightly. It might take 1 9 off it, but it wouldn't have in my opinion, a significant effect on it.
I follow, thank you. And if we could look at one more, please, which is 110668 to 110674 at page 110671. Now, on this occasion, you can see that a prior probability was left at the level of 0.5. And I think you discussed this with the prosecution in a preparation session back in July of 2023. And I'll just read to you one of the things that you said then.
Sure.
For the record, it's at page 114018 at paragraph 6. You said 0.5 is a reasonable value in this context, given the circumstances of the exhumation of the remains from a named grave, brackets, presumptive identification. Do you recall giving that explanation a year ago?
It sounds familiar.
And so in this case, the fact that a body has been exhumed from a named grave has been used to reduce the prior probabilities to 0.5.
Yes, the 1 in 3,000 prior probability would assume we have no information about who the individual is, and it's a completely random chance. Whereas in this case, when there has been an identification carried out, you could argue whether it should be 0.5 or slightly different, but I would say it would be consistent with normal practice.
Yeah. But of course, you would have no information about the factual circumstances which led to a particular body being in a particular grave.
No, I do not.
And so effectively what's happening with the prior probabilities is that a factual assumption is being introduced into the calculations. That's right, isn't it?
That would be true, yes.
And you're not in a position today to verify whether that factual assumption is correct or not.
That is correct.
Thank you. Could I then move to the second topic, which was the population substructure adjustment?
Yes.
Now, the background to this is that you had explained in a footnote to your first report that no corrections for population substructure had been made.
That's correct.
And you then explained the position a little bit further in your preparation note.
Yes.
I just want to read back to you part of what you said at paragraph 6 of the preparation note. You said, correction for population substructure would reduce the figure a little. Generally, in an identification report, correction for population substructure is not included. From a criminal prosecution perspective, correction for population substructure would more commonly be included, but this varies from jurisdiction to jurisdiction. Do you recall saying that?
That is my understanding, yes.
And can you explain why it is that from a criminal prosecution perspective, this correction would more commonly be applied?
It was to be to err on the side of caution and reduce the likelihood ratio.
And so far as we can tell, from the face of all of these reports that have been provided, no such correction has been applied, has it?
I do not believe a correction would have been applied at this time. at the time that these reports were produced.
Presumably in
But
part.
I don't know that, but I don't believe they have been. And I don't believe they would be for this type of work typically.
Because these are identification reports, they're not criminal reports.
Exactly.
Yeah, I understand. And you gave the example this morning. You were speaking about one specific example with Mr. Patch for the prosecution. And on that example, you said, I think, at transcript page 20, that the effect would be to reduce the figure of 216,000 as a likelihood ratio to around 15,000.
That's correct.
And of course, that correction has not been applied to all of the other 25 or however many exactly it is that you've looked at.
That's my understanding.
Yeah. But if it were to be applied, we would probably see a reduction in all of those cases.
Yeah, it would certainly, if you applied it and it hadn't been applied, it would lower the likelihood ratio.
And without going through the exercise of applying the calculation to each case, we don't know how much the reduction would be in each case.
No, typically they're in the region of 10 to 20-fold, but it depends on the specifics of the case.
Thank you. Just a moment. Thank you very much.
Thank you.
Those are my questions.
Redirect examination.
Yes, thank you, Your Honour. We can take the document that's on the screens down. And good afternoon this time.
Good afternoon.
So witness. At pages 88 to 93 of today's transcript, so just earlier during the Veseli cross-examination, you were taken to your general comments in relation to a number of documents. And those general comments are, and we can call it up in your first expert report, that's now MFI P01951, pages 11, 12, and we'll start from page 11, which is page 103383. Now, as that's being called up, witness, the counsel summarized or paraphrased in their question from one of these pages, where you elaborated on some of the aspects of the reports which are not standard. Do you remember that question and answering?
I do, yes.
Now, so if we turn first to page 103384, the next page, and we look at the top. So there is the three bullet points are what counsel summarized to you. And if we go back to the immediately preceding page, at the bottom of that page, thank you, we see at the bottom an excerpt that you were referred to but was not read out. So here we see, I'm quoting, the key elements of a DNA report are present, but there are some aspects which are not standard. Now, witness, you confirmed during cross-examination the second part or the second clause of that sentence, and my question is whether the first part is correct. That is, that the key elements of a DNA report are present in the multiple DNA reports to which you're referring to in this excerpt from your report.
When we're talking about the key elements, yeah, we're looking at a DNA profile for the ones where they are available. That would apply. The biggest non-consistency with the standard report is the encryption aspect.
And other than that biggest inconsistency, is what you said here correct today as well, that the key elements of the DNA report are in fact present?
It depends. These are a streamlined report. So they are the report, obviously, where the ICMP have been commissioned to do the work, and they are providing information as I'd expect them to work. So the profiles are there, whether they're encrypted or not. The summary is there, whether they're encrypted or not. The names are there, and the relationships are there. So most of the key information is there, but with the caveat, with the encryption, it makes it hard to interpret that without de-encrypting it.
And we can take this document down. At page 114 of today's transcript, still during the Veseli cross-examination, you were asked about a document which I'd like to call up, and that is SPOE 0068661-000068678. That's going to be from the Veseli presentation queue. And we'll go to the first page of that document that was shown to you. Now, if we scroll down a little bit to the bottom of the page, do you recall counsel noting that the person signing off on this particular document is a forensic anthropologist?
I do, yes.
And if we can zoom in on the signature block, please. Do you see that he is here signing off as the head of the Office on Missing Persons and Forensics?
I do, yes.
Now, if we read the paragraph immediately preceding the signature block, we see that this reads, "The Office on Missing Persons and Forensics has compared the antemortem and postmortem information, and the results collaborate the above." Now, would you agree with me that it seems to be saying, rather than collaborate, perhaps corroborate would be more logical?
Corroborate would be a better word.
And when reference is here being made to the above, we can see, if we just zoom back out a little bit or from recollection, that the above is the DNA analysis that is summarized or referred to. Is that correct?
The DNA and also I believe the anthropology. Yeah, the antemortem, postmortem data in general.
Now, in your capacity as an expert on forensic genetics, to your knowledge, is such a comparison, the one noted here, between antemortem, postmortem information, and DNA results, something that is to be expected in an identification report?
In an ideal situation, all the information available should be used to form the opinion of identification. So this would include antemortem, postmortem data, circumstantial data, any information which is considered a line of evidence would be, in an ideal situation, included in the evaluation.
Thank you. No further questions.
Thank you. Judge Barton?
Yes. Thank you, Judge Smith, and good afternoon, Mr. Goodwin.
Good afternoon.
The panel has a few more questions for you that we believe are necessary to better understand your evidence.
Okay.
And my first question is this. I assume you're familiar with the work of the International Commission on Missing Persons, or ICMP, is that right?
I am, yes.
So may I ask you to comment in general on the work of ICMP in the field of DNA analysis, and in particular on the standards and methodology applied?
Yes, they have been, they were established in the late 1990s in response to the conflict in the Balkans, and became operational at the end of that period, early 2000s. They have really pioneered the use of DNA-led identification in this type of work. Prior to this, it was only using DNA to test and establish presumptive identification. So as such, they have pioneered the use of the DNA-led approach to human identification, in particular in post-conflict contexts, but also in DVI, disaster victim identification, which has many of the same challenges. So they are a highly respected organization. They have published a lot of the papers which the rest of us follow now when extracting DNA from bone samples and carrying out comparisons of DNA profiles from bone samples and reference samples.
Thank you, Mr. Goodwin. We understand the reservations you made with regard to what you can and what you cannot say about the individual DNA examinations, but when preparing your reports, did you have or do you have any doubts as to the standards and methods used by ICMP in their respective reports?
In general, no. In general, I would say they have established the benchmark for the methodology to be used in this type of work. A lot, not entirely alone. There's other laboratories around the world, like the American Armed Forces Identification Laboratory, which have also set precedent in how to go about using DNA for identification. But certainly in terms of processes, I have no reason to question what they're doing.
Thank you. And do you have any indication that there were flaws, shortcomings, or inconsistencies in the analysis of the DNA samples that would affect the conclusions of ICMP? And if so, could I ask you to summarize those flaws, shortcomings, or inconsistencies again for us, if there are any?
Based on what I have seen and what I have knowledge of the ICMP, I do not have any specific knowledge of flaws in their processes.
Thank you. I have no further questions. Thank you.
Thank you.
Judge Petro? Judge Gaynor?
Thank you, Judge Smith. Good afternoon. Sir, I was wondering if you could help us understand some of the evidence you gave about allelic values or allelic designations.
Yep.
I think you said that a value such as 4.9 is much rarer than a value such as 4.0 or 4.1. Is that right?
4.9 would not exist. 4.0 could exist, yes.
And just very briefly, why is that?
Well, because we would, if we had an allele 4 and we added one more base to it, it'd be a 4.1. If we added 2 bases to it, it'd be a 4.2. 3 bases would be a 4.3. But if we add 4 bases to it, it becomes a 5.
Right.
And so we never get more than 0.3 unless we have these 2 penta repeats.
Now, in some of the tables of data that we saw earlier,
Yes.
we saw, for example, a sample where both allelic values 7.9 and 4.9 appeared.
Yes.
And how likely is that to happen? Or is it even possible for that to happen?
These, I believe, are through encryption. I think this is where the alleles have been encrypted, and they're not the actual allele.
Okay, so perhaps it would help if we bring up a document here. Could I ask the court officer to bring up SPOE 00291803? Now, I think we see in this sample, we see the value under ICMP 3, 7.9. And under ICMP 13, we see the value 4.9.
Yes.
So in this particular sample, we have both 7.9 and 4.9.
Yeah.
Now, what am I to understand that that is not possible?
No, this is an encrypted. This is not the STR profile. This is an encrypted profile. I'm sure this is an encrypted profile.
Now, on the question of encryption, why would the allelic values themselves be encrypted? I can understand that the person's individual name or date of birth or personal information might be encrypted, but why would the allelic value be encrypted?
Potentially to stop the DNA profile being used for a purpose outside of its use in this identification. So, for example, looking at paternity, non-paternity, in another related case,
Right.
or relatedness between individuals who are involved in the identification process.
Now, in the data that we're looking at, the top row relates to the sample of the deceased. Isn't that correct?
That's correct.
And then the relatives, those are all samples which are taken from living persons. Is that correct?
That is correct.
Now, among the samples taken from the living persons, again, we see the values 7.9
Yes.
for 3 of them and 4.9 for 4 of them.
Yes.
Could you explain what's going on there?
I believe, and this is an assumption on my behalf, that when we are looking at the code for the STR allele remains the same. So, for example, can I draw on with the pen? It might help.
Please go ahead. Yeah.
So you said about 7.9. Okay. If we go to the 7.9 and 7.6, so they're the two alleles, and we go to the Son, we would expect one of those alleles to be inherited. And so here we see a 7.6. Below there we see a 7.9. So for each one, it could have been either of those. Oh, that's a mother, sorry. I don't know if I can rub this out. Let me just rub that out so it's easier. So we would essentially, what I think is happening with this, and again, it's an assumption, is that in each case where we have an allele, so ICMP3, when that allele is coded 7.6, that coding remains constant throughout this case. Not necessarily between cases, but within this case, every allele which is the same as 7.6 will be coded as 7.6.
All right, so what you're saying is that the true allelic value is not actually represented in this table, either for the deceased or for the living persons.
Correct.
I see. Then if we go to the conclusion section, if perhaps Madam Court Officer could you just move the, or would you like to? Yes, if we can save that, please, and give it an MFI number, perhaps.
I mean, I would just add, whilst we're doing that, I would just add that if we look at the wife's genotype, the wife has got 8.7, and then both the son and the daughter also have 8.7, which is what we would expect, because we expect the children to be comprised of alleles of the two parents.
Yes, but even in that example, the value 8.7 would itself be extremely unusual.
8.7 does not refer to an STR allele in its normal way, so this is why we say, I'm sure it's an encrypted value.
Okay. Now, further down in this document, the conclusion says, and we've seen it before, that the probability of relatedness as described on this report is greater than 99 point, and then I think it gives 5 nines.
Yeah.
%.
Yes.
So it's an extremely high degree of
yes
probability.
Yes.
And just so that we are best able to understand this, that conclusion of an extremely high degree of probability is based on allelic values which are not in fact represented on this piece of paper.
That is correct.
So in essence, we are trusting the ICMP expert to have carried out their work accurately in reaching that conclusion.
Correct.
We're not actually relying on these figures. Is that right?
We have to take their conclusion, and we cannot evaluate the data to see if we agree with it. So we have to take it on trust that their conclusion is correct.
I believe that deals with most of my questions. I just had one other, and that is, are allelic values in any way affected by saponification or any kind of degradation of the material?
The allelic value would not change. What might change is that you're not able to ascertain what allele it is, but it would not change the allelic value.
Right. Do you happen to know if the ICMP staff involved in these reports had previous experience in Bosnia themselves or in other conflict areas?
Most of this work, I understand, was carried out in Bosnia. So the laboratories of ICMP at this time were situated in Bosnia.
I understand. Thank you. No further questions.
Thank you.
Any follow-up questions? Oh, On, am I correct? It's 00291-803. Should have an MFI assigned to it.
Thank you, Your Honor. The markings made by W4875, document SPOE 00291803, will be registered with the register number REG 01198 and assigned MFI number C0000401. 401. Thank you. Classification is confidential.
Thank you. Any follow-up questions, Mr. Patch?
I'm grateful, Your Honour. Mr. Goodwin, just two short questions arising from the judge's questions.
Yep.
The first one was in relation to a question that you were asked by His Honour Judge Bartha at the outset. And it was in relation to whether or not you could see any flaws, shortcomings, or inconsistencies in the work that was done.
Mm-hmm.
Do you recall that question?
I do, yes.
Would you agree that in the absence of the EPGs, you are unable to confirm that the results and conclusions are absent any flaws, shortcomings, and inconsistencies for these reports, because you can't check the existence of such?
No, absolutely. I mean, for what I can, there's nothing that flags as wrong, but I cannot, as you have pointed out, go back to the EPGs and verify that what is in those reports is correct.
I'm grateful. So no red flags, but they can't be confirmed.
Not from the data I've been given, no.
And secondly, you were asked a series of questions by His Honour Judge Gaynor as well in relation to one of the reports that we had put up on the screen.
Yes.
And I just want to deal with an answer that you had given to the judge, which was that you stated that you are sure that the profiles are encrypted. Now, just dealing with that. What you can be sure of, and of course sure as a term obviously carries significant weight when we're dealing with criminal proceedings.
Yes.
What you can be sure of is that the numbers that we see reflected in those reports can't be allelic designations. Of that you can be sure, is that right?
That is a fair point.
Yes. So there we have certainty. A 4.9 is not an allelic designation, correct?
Correct.
You believe that the explanation for that is that this must be encrypted.
That is correct.
But you cannot be sure it is encrypted, but you believe that to be the most likely explanation for what you can be sure of, which is that it's not an allelic designation.
I would accept that.
I'm grateful, thank you.
Ms. Tavakoli, anything?
No, thank you.
Mr.
Thank you,
Tully?
Your Honour.
Mr. Ellis?
No, thank you, Your Honour.
Your testimony is completed. We thank you for being with us and sharing your information. You may leave the courtroom now with the court usher. We wish you our best.
Thank you, Your Honours, and thank you, Counsel.
Mr. Patch, I believe that on the prep note, you listed all of the exhibits that you intended to submit. Is that correct?
Yes, correct, Your Honour. Annex 1 of the prep note contains all the exhibits we intend to admit, which includes also the ones MFI today. And just to highlight also the page numbers from certain exhibits, since some of them are not tendered in full.
So, objections?
Your Honour, yes, multiple. And Your Honour will also be aware of various legal arguments raised by the defence collectively in writing previously. We would ask Your Honours for an opportunity to respond to each item individually in writing and invite the panel to set a timetable for us to do so. In light of the evidence we've heard today, we would appreciate the opportunity to consider the testimony and respond fully in writing. Of course, this evidence doesn't impact on any upcoming testimony, so any delay in any decision should have no impact on the speed or efficiency of proceedings.
Yes, Your Honour, just to note that, as the panel knows, the defence has already been given the opportunity to comment on the appropriateness of the admissibility of these items, and the decision of the panel didn't say until after the defence makes even further submissions. It said until after the questioning is conducted. If there was any information that counsel wanted to elicit from the witness in terms of admissibility of these items or otherwise, the defence had every opportunity to do so thus far. So in our submissions, that ship has sailed, and now it's just time for the ruling of the panel.
Your Honour, if I may briefly, counsel are expressly prohibited from making submissions or comment while asking a witness about a document. So therefore, until this point, we have been in no position to make comment on documents. What we have been in a position to do today is to establish a factual, establish the facts as per this witness's evidence. And what in our submission we are entitled to do is the opportunity to comment on the facts and the evidence that are now before the court. We are entitled to comment upon the admissibility of this evidence in light of the evidence that we have now heard that has been subject to the questioning of both parties and to the panel. And there is no reason, expedition, fairness or otherwise, to deprive the defence of the opportunity to properly respond to the only DNA expert evidence in this case properly. There is no reason for additional expedition.
Your Honour, if I may very briefly, just so the record is clear, counsel seems to be forgetting an annex that they filed with detailed objections as to each item tendered and a code used for each of those objections, which code is later explained in an annex and written submissions. That is certainly the comment and the submissions I was referring to. I, of course, was not suggesting they can elicit or make comment in court with a witness.
Your Honour, can I simply add our weight to joining Ms Rowan's submission? Given the number of different documents being tendered and to take into account the oral evidence that we've heard this morning and the early part of this afternoon, we would say the efficient way of dealing with this, given that there are mixed factual and legal issues, some of which will be common to many of the documents, but some of which will need to be tailored to each specific document, it's likely to be more efficient in our submission and more just, if I can put it that way, for us to develop the points in writing.
Your Honour, I'm also reminded helpfully from my left that when DNA expertise was heard in this tribunal in a different case, the defence in that case was afforded the opportunity to respond in writing. So in my submission, that is the practice of this tribunal, and there is no reason to depart from that for this case and to deprive us of the opportunity that the defence in the Shala case were afforded to respond in writing.
Your Honour, if I may add our support to the submissions of our learned friends, and in my view, there must have been a reason why Your Honours didn't rule on the admissibility of these exhibits pending the testimony from the live expert witness, and for the reasons outlined by Ms Rowan, we would submit that now is the time to make submissions as she's outlined to enable Your Honours to reach a decision.
We're going to take a short break and we'll come back and give you an answer.
All
We're
rise.
adjourned for 15 minutes.
All rise.
Be seated. We will allow the Vaseli defense to file a brief supplemental to their previous statement by Friday, not to be repeating any of the information that was already in just focused on any new information that you had here. SPO can respond by Monday. There'll be nothing else beyond that. That's the ruling. We're adjourned until tomorrow at 9 o'clock.
Your Honour, can I just check, please, that applies to all the defence? I think it
I'm sorry,
authorises the
I couldn't
Vasselli
hear you.
defence to respond. I think your order literally allowed the Vasselli defence to file on Friday. We may wish to file as well, so I assume it applies to all defence. I apologise, Your Honour. Reading your order literally, Your Honour, it allowed the Vasselli defence to file on Friday. We will.
Your Honour, if I may, just in terms of logistics, could the deadline be set for 4 o'clock on Friday to ensure that we're served with it on Friday itself?
Nothing further. We're adjourned till tomorrow.
All rise.